P. DeLong versus King. Both parties are present via Zoom. Mr. King filed a motion to enforce a tax refund for the last 7 years or something like that. I've looked through the court orders and stuff like that. Mr. King, there's no court order that gives you tax refunds.
No, there is no court order, sir, that does give
And
me.
I can't enforce anything. I can't enforce an order that isn't out there.
Where would there be a tax and court order for Miss DeLong as far as any tax refunds?
There, that's between you and the IRS. It has nothing to do with the court. You're asking the court to enforce something that I have nothing to enforce.
When I came down, they said I had basically a case here for this.
I don't care what they said. I have nothing to enforce if there is no court order to do this. Nothing.
No, because there wasn't anything as far as given upon the other party, letting them know
That's
that.
right. And so I cannot enforce anything that's not in a court order.
But if the child already was living with me and that court order pretty much is now dead because she actually submitted to the court saying that he lives with
Mr.
me.
King, you're not listening to what I'm saying. A court can only enforce orders that I have, and I don't have an order to enforce.
So what would be your recommendation from here, sir?
Don't make recommendations to parties.
Okay.
I'm here to enforce a court order. There's no order to enforce. Therefore, your motion has to be denied.
Okay.
All right. Mr. DeLong, you can say something, but there's no reason to because I'm denying his motion. There just isn't. It's between you and him and the IRS or whatever, and waited 7 years to try and do something. And I have no idea what an outside agency will do, but I'm not going to enforce a court order that is not present. So
thank you.
I'll deny it. Thank you, everybody. Take care. Have both parties are present via Zoom. This is a motion that's been filed. Apparently by, I believe, the plaintiff father seeking a temporary order in this particular case. There are 2 5-year-old children. A complaint for custody was filed late last month, and he is seeking to have sole legal and physical on a temporary basis and stuff. Says that the mom gave him the kids are living with him, and said she verbally waived her parental rights to the father. What else have you to say, Mr. Aguirre?
Just that we both came to an agreement that I was gonna get the sole custody of the kids. It was discussed earlier.
Like when earlier? Like earlier this week or what?
2 weeks ago. More or less.
So what, ma'am, what are you agreeing to here on a temporary basis?
I'm agreeing for him to stay with the girls just for a little while I get everything situated. And then once I get everything situated in my personal life and everything's all good. Because I have another child as well. And 3 kids for me is a lot. So, he offered to take them and, I'm fine with that. So that's basically it. I know my girls are in good hands with them and that's where they want to be. So.
Well, this is only a temporary order anyhow. It's not permanent. So you're allowing a temporary that he will have physical custody. I'm assuming you wish to have.
It's just temporary. It's not I didn't want it to be a permanent thing.
What kind of parenting time? As agreed?
As agreed, yes. We still have to talk about it.
So we'll give him sole physical. You can have joint legal so that the 2 of you can still discuss any significant things with the kids. It sounds like you kind of do get along. So physical to dad.
Yes.
Joint legal. Parenting time as agreed. What do we do about child support?
No child support.
We'll reserve child support for a later time. All right, because it's just a temporary order. All right.
Perfect.
All right, we'll get that out. You should get copies of it in the mail in a week or so. All right, we'll send out that the 2 of you can continue to work on this matter, and hopefully you continue to work together on it. All right.
Okay. Just a question: how long is temporary to the agreement that we're
discussing? To the point where you got to bring in something to finalize your custody order. Okay.
Okay.
And it's temporary out there, and at some point, somebody's gonna have to try and finalize a custody order one way or another, because that's what you filed as a custody case. But normally, get this, you'll probably get some thing from the court saying there'll be a status conference or a settlement conference in the future, and you can try and work it out and everything, all right?
Okay, then that's when I would be able to settle with the full custody.
That's up to the two of you, okay? And if you can't, then we ultimately have to have a trial. But you guys should be able to figure this out. All right?
Okay, understood.
All right. Good luck, everybody. Thank you. Have a good day.
Yep,
Thank
you
you.
too. Bye-bye.
I'm doing a lot of stuff here that I'm not used to, so I gotta go and find out. Cruz de Jesus versus Thompson. Both parties are present via Zoom. This is a motion filed by the defendant mother seeking child support. There was a final custody, parenting time, child support order entered just in August of this year, and the matter of child support was referred to the friend of the court. No one cooperated with the friend of the court, so they dismissed the referral. Ma'am, why didn't you cooperate with it last time? You want a referral now?
I didn't even have, I don't know if it's that I'm just not paying attention real good to the mail, but I never received any notice. I know that I received it with Brian and I did show up for Brian, so I don't understand why I wouldn't show up for Jason.
I have no idea. If they have your correct address, they sent out stuff. Mr. Dela Cruz, you didn't cooperate either.
As far as I know, last thing I heard about that day, she had canceled it. That's what she told me. You can even ask my son. Then
Well,
my
I'm not
son,
gonna ask your son. I'm not gonna ask your son.
she told me she canceled it, that she didn't want to
Well-
keep going with it.
All right. I'm gonna tell you right now, ma'am,
Well,
I'm gonna refer it to the friend of the court one last time. All right. They're gonna send out and ask for information from both of you to see what, if any, child support is appropriate. All right.
Okay.
Okay.
You better have the correct address with the friend of the court, and you better respond, because if they don't get any response and send back a notice that says they didn't respond, I'm not going to continue to refer it. They do their work and they expect you to do yours.
Okay, so I just want to make sure that I have everything good because I think my health is really bad and my health has been like on the top of my mind and I forget stuff real quick. Just want to make sure. So you send out the referral.
I
They
send a
contact-
referral to the friend of the court. They will see who the parties are and send out information that they want you to provide to them so they can make a decision, like how much money do you make and other kids and how much time does he get and this kind of stuff. And they expect a response from both of you. So you better make sure that the friend of the court has your appropriate address so they can send it out. Mr. Cruz, the same to you, because otherwise if they get information from her and not from you, they'll just go ahead and figure out what they think you should pay and you won't have anything to do with it.
Got it.
All right, good luck. We'll make the referral.
So I gotta go to the front of the court now.
What?
So I have to go to the front of the court and make sure they got the right address.
Well, you can contact the front of the court and make sure they do. I don't know if I don't know. All I'm saying is they're going to send that stuff out to you. And if they don't have your correct address and it goes out and comes back, that's on you, not on them. They can't chase you around. So you can contact the friend of the court and send them a letter or something saying what your correct address is, whatever you need to. Good luck, everybody. Thank you.
Thank you.
Is this the last one?
Yeah.
Hate it when you lie to me just like this. I'm used to it, but. Yes, Delgado versus Rodriguez. Both parties are present via Zoom. This is a motion filed by the plaintiff mother seeking to obtain a passport for the party's child. She hopes that in the future to be able to go to Mexico, apparently. Mr. Rodriguez, do you oppose getting a passport?
Yes.
Why?
Because I think she's going to Mexico, and the area she's going to, we have this big cartel in Mexico where
The first thing I'm asking is to oppose a passport. I'm not authorizing her to go to Mexico at this point. I'm authorizing her to get a passport.
yes, I oppose.
All right. Ma'am, you still want a passport?
Yes, I do.
I think you should be allowed to get a passport. However, your request to go to Mexico is premature. You can't go there until you get a passport, and you can't leave the country necessarily unless you two got to discuss it. And he says it's a dangerous area and all that kind of stuff. We'll see at some later time. I'm not going to give you permission to go to Mexico at this time, but I'm going to give you permission to get a passport.
Sounds good.
All right, I'll give you a court order that you can obtain a passport if Mr. Rodriguez is not going to participate in it. That's
Okay.
You got to understand, sir. That's all I'm saying. Is I'm not giving her permission to go to Mexico any more than I'm giving her permission to go to France. All right. She is at this point going to get a passport. Ma'am, don't abuse it. We're here
Okay.
in 23-799-6 DS. It's Gracie V. Getter. This is a couple of motions from Mr. Getter, apparently. First, he wants custody. And second, he objects to a child support order. We'll deal with the custody matter first. What do you have to say, Mr. Getter? You want custody of the two minor children? Is that what you're asking for?
Yes, sir. Or either split custody.
Well, the only order in this case is a standard DS order. That gives basically initial custody to mother, but without prejudice to either party seeking it. That means you don't even have to fulfill the Vidvarka standards as I understand it. So the only way I can determine custody, I can't determine it on a Friday morning, is to set up an evidentiary hearing in which we will have a determination of custody. Ma'am, do you understand that I can't do anything other than set up an evidentiary hearing? You have initial custody through the DS order, but it says without prejudice to the determination of either parent's custodial rights. So I have to set up an evidentiary hearing unless you guys agree on custody at some point. We'll have an evidentiary hearing. I'll send out notice to you, and you better follow the notice. It will be in person, and you're going to have to submit certain things. So
Okay, I appreciate that. I just got one problem with that, sir.
What?
She's holding my kids from me. Like she won't let me see them as of now or
Well,
before.
you apparently don't have a parenting time order. Is that correct, ma'am?
That's correct.
You filed for custody. I'm giving you a custody hearing. You'll obviously get some time. At the custody hearing, we'll try and figure out how custody, parenting time, all those things should go. Ma'am, why are you holding the child from him at all times?
That is false. And both of my kids have their own devices, cell phone devices, where he can communicate with them anytime he like.
How old are your kids?
6 and 11.
6 and 11?
Yes.
All right, but does he get a chance to see him?
No,
Yeah,
sir.
whenever he
No,
wants to.
sir. I can only
Okay.
see my kids when I call, and like she just said, they both got their own phone. I call their phone every day. I've even got the cell phone records to prove it to you. I call them every day. She just don't let me come get them.
Sir, let me, I gotta ask her a question without you answering.
Okay.
Ms. Bracy, does he
Yeah.
get an opportunity to see him, and why can't he see him on a regular basis, like in every other weekend or something, until we get to this hearing?
He can see them whenever he like, just like it's been. He's telling you false information.
Yeah,
I don't keep my boys from him whatsoever. Whenever my boys want to go with him, and they
There's
say, "Mom,"
there's nothing to enforce unless there's some kind of an order, all right? And so
Okay.
do you want him to get him every other weekend right now so that we can get something going?
Yeah, he can get them every other weekend. That's fine.
Friday, kids get out of school at 5 o'clock till Sunday at 6 o'clock?
Sunday at 5.
Can we do it every weekend?
Every other.
Usually the court doesn't grant every weekend only because of she'd have a chance to do some stuff when they're not in school, but we'll do every other weekend and every Wednesday night from after school until say 7 o'clock.
Okay.
School night at 7 o'clock. I don't agree with that.
Well,
See, this is my problem,
Mr.
Judge.
Getter, stop. Ma'am, it's my order. It's not whether you agree to it, all right?
Okay.
He's got to see his kids, all right? So we'll have it
Agreed.
Wednesday. Why? What time do you say he should see him? After school until what?
Sunday. I mean, 7 is kind of late. They're getting ready for school. So, I mean,
What time do they go to bed? They don't go to bed at 7 o'clock.
no, they don't, but they're taking showers, they're eating, they're getting ready to go to bed.
Well, they're gonna get food when they're with him. He's gonna feed them.
Okay.
All right? He's gonna be a regular dad, and he's gonna see him from after school on Wednesdays through till 7 o'clock. He's gonna take him to dinner or feed him and maybe do some of their homework and do just regular dad stuff.
That's fine.
I
When do we
appreciate that,
start?
Judge.
When we starting every other weekend, this weekend or next weekend?
Let's start this weekend.
Well, ma'am, that work?
Yep, that's fine with me.
All right, the person getting the children will pick them up. So Mr. Getter, you'll pick them up. And at 5 o'clock on Sunday, ma'am, you'll go pick them up from him. That way there's no doubt in what's happening. All right?
Yep.
And every Wednesday, 5 to 5. Wednesday after school until 7 o'clock. Just be a regular dad, see your kids, and let's see where we go after this.
That's all I've been trying to do, Judge.
We'll set up an evidentiary hearing. I may. Would you like this referred to the friend of the court for them to take a look at it before I have the hearing, or you just want to set up the hearing because it's going to be a couple months before you get a hearing?
You
I'm
can just
gonna
set up the hearing.
Just set up the hearing. All right. All right. Look for things in the mail. You have to abide by them. You're at a huge disadvantage if you don't get an attorney. Telling you right now.
Okay. And will it be like a friend of the court attorney, or will it be a regular, like, what kind
You
of
gotta
attorney?
hire your own attorney. I'm just telling you that you're at a huge, if one of you comes in with an attorney and the other doesn't, it's a huge disadvantage because you have to show such things as an established custodial environment. You have to go through each of the best interest factors, none of which are you in tune with. And so that makes a difference as to the burden of proof and everything. This stuff I'm talking about, I doubt is very familiar with you. You should go try and talk to an attorney, see if you can hire. If you show up without it, I'm going to only hear legally admissible evidence. That means you can't come in and say, you know, my friend said that these kids should be doing this and that. That's hearsay. You got to follow the rules of court when you come in. So I'm suggesting that you both go get an attorney or you're going to be at a great disadvantage. But as of right now, we'll issue this order. So it's every other weekend. You'll start by picking up the kids on today at 5 o'clock. Good luck, everyone. We'll see you back at some time in the future. Thank you. Both parties are present via Zoom. This is a motion filed by the plaintiff to change the pickup and drop-off location to the Grand Rapids Police Department. It's my understanding that this was just a court order from 3/3/23, just earlier this year. It appears that the current location, I think it's from release from school and the other parent's residence. So in other words, if Mr. Grable was getting him, he'd get him from school and then you'd get him from his residence or vice versa. Is that correct? Does anybody know that whether that's
yes? So no, that is not correct, Your Honor. In the judgment of divorce, we were supposed to meet at 5900 Byron Center, which is the hospital. And then the Miss Grable moved from Holland to Grand Rapids area. So we
when is that order?
That was should have been February 28th is when we finalized the divorce, and I think that was it should have been in the JOD.
I'm reading from it right here, exchange location. And this was an order from 3/23, which must have been the date that the judgment was entered. There's a custody, parenting time, and child support order entered 3/3/23. And it says exchange location. The location of exchange shall be the other parent's residence unless occurring upon release from school when it will be at the minor child's school. I'm reading from this.
Oh, sorry, Your Honor. I think we were both under the impression that we were supposed to meet at the that Byron Center Hospital originally. And then she moved and we've met halfway at a different location, and she's proposing a third location since March.
Why are we doing hop around trying to exchange locations?
Your Honor, I was requesting the police station because I don't feel safe. And the police station I requested, I realized there's no parking downtown. So if just any police station that could be convenient for both of us.
Why, has there been something that's happened? Sir, pick a police station.
I'm sorry.
I just asked him to pick a police station. That's
Yes,
all
Your
you
Honor.
did.
Yeah, so I mean, if you know, I'm not opposed to changing it again. The one that I looked at that would be between both of our residents, and I think would be in the best interest of like the children if we do that, would be the Kentwood Police Station on Walma. It looks like it's 6.7 miles from her residence and 8.6 miles from my residence.
That has a parking place. We'll do it at the Kentwood Police Department on Walma.
I do have one other request, Your Honor.
It's not filed properly, but let me hear what you have to say.
So just based upon the meeting spot, because I do have the children the majority of the week, I do work 9 to 6. So I was hoping instead of 6, we can move because we're changing the locations a little farther from work, that I can we can meet at 7 versus 6 p.m.
Your Honor, I feel as if that's too late. They're very young children. It's already hard enough at 6 o'clock to get them back, dinner, bath, bedtime.
Well, but Jesus.
And unfortunately, I work till 6 sometimes, and she's not
How old are
cooperating.
these kids?
5, 4, and 1.
And you're gonna have to deal with this forever. You want to change locations every time you turn around. This will be the third location in probably 7 months.
That's correct, Your Honor, unfortunately.
And you have them there at 6:30?
I can try. Yeah, it's just when I come at 6 to come back the opposite side of town, the current spot that we're meeting at is Home Depot on 28th Street and Patterson, which is a half a mile from my work. So it you know, if we're changing again, I'm not opposed to changing to a police station. It's just, you know, it's just not feasible if I work 9 to 6.
I understand, but if you get out at 6 o'clock and if you can be at Patterson and 28th at 6 o'clock or minutes after, you can be that. It's only out to 44th Street and down towards that. You can be there by 6:30.
Yeah, that's fine.
If you know, if we're having a snowstorm, text her, say I'm going to be a few minutes late, or you text him and say I'm stuck. That's one thing. But as a general rule, the exchange will take place at 6:30 then p.m.
Perfect, Your Honor. And this is this effective as of this week, or do we have to wait till the motion's filed and completed?
Well, I mean, until the order is filed?
Yes, sir. I'm sorry.
You'd have to wait for an order, but if the two of you agree to start now, start now.
Okay. Thank you, Your Honor.
So tonight the exchange will take place at 6:30 at the Kentwood Police Department, right?
Oh, so yesterday we exchanged, but yeah, so on Monday we'll exchange there.
Monday we'll start there because you will not have a court order in your hands by then.
Okay.
Right, because you should draft it, but I know we're going to. And
Sure.
We'll get the order out to both of you. The exchange time will then be at 6:30 and at the Kentwood Police Department. All right. Good luck,
Thank you,
everybody. Thank you.
Thank you.
Hello?
Yes, sir. I can hear you. Can you hear me?
Yep, I can hear you.
All right. Hold on just a second. Sharon, if you're there out in California where the weather's nice. Suzanne in Romania. All right.
How about that? Thank you.
Singer. All right. I was just filling in time and I didn't want to start singing because that would have.
Well,
so I'll leave that to you, Mr. Cox.
Friday.
I'll leave that to you. Next time you can prepare a song for us.
There will be just by word of warning, there will be dogs howling if that happens. But anyway.
All right. What would you like to state about this? It's my understanding you've reached an agreement on this matter.
Yes, Your Honor. Thank you. My client and mother in the case have reached an agreement where she has agreed that my client will have full legal custody of the minor child in this case, and that the minor child will not be around Adrian Peluso, who is apparently a gentleman that mother is dating, and that would resolve the issues. In our motion, we have an order signed by Alex Camineri, and of course, my client and myself relative to those issues.
All right, if you have a stipulated order, get it in to me and I will be more than happy to sign it.
Thank you very much, Your Honor. Appreciate it.
Thank you. Have a good weekend, everybody.
You too.
Take
Have a
care.
great weekend.
Mr. Getter, Ms. Bracy, we need you on again.
Yeah, I'm still here.
Yep.
I think you're calling me back right now. 1 second, okay? Can I?
All right.
I'll right back, okay? Yeah, I'm here though, Judge.
We needed to have the prosecutor come back on to deal with your court order objection.
Yes, sir.
6DS Bracy v. Getter. This also, I made an order that he is to get every other weekend and Wednesday evenings. We're setting this up for an evidentiary hearing for custody. Father also filed an objection to the child support order that was entered with him. He and claims that I don't know that he shouldn't. Sir, did you object to this before?
Yes, I objected a few weeks ago.
Well, Ms. Rummel, what have you got to say about this?
Thank you, Your Honor. This he was served in this matter August 24th. He filed an answer. The address he provided on the answer was a Burton Street address. We scheduled a pre-hearing. It was noticed to that Burton Street address. He did not participate. Neither party did. Neither party answered the phone when I called them. Child support was based on plaintiff's actual income of $15.45 an hour, working 40 hours a week, with 341 overnights and one other child. Defendant earning an actual income of $12.39 times 40 hours a week, which was his average for the first 2 quarters of 2023. With 24 overnights and no other children, the calculation resulted in base support of $522 and ordinary medical of $36 for a total order of $558 per month, with the medical split being 52% to plaintiff and 48% to defendant, and the effective date being September 1st, with birth costs being waived. Defendant called immediately after the pre-hearing, stating that he hadn't gotten notice. He had moved to a 44th Street address. Our office requested that he send in verification of his new address so we could update it. And he was given verbal notice of an October 6th hearing that I was scheduling before Your Honor. Notice of that hearing was sent to his Burton Street address, even though he had reported over the phone that he had moved to 44th Street. So on October 6th, the hearing went forward. Again, no one participated. The orders were entered. Defendant called in immediately after the hearing and asked what happened. And again, said that, he wasn't receiving notices. He did come in October 16th to our office and updated his address to the 44th Street address. And then he filed an objection on October 30th, which would be more than 21 days after the entry of the orders. The objections that he placed were primarily that he didn't get credit for enough overnights. I don't think he's objecting to the income that I used, but I will let him make those arguments.
No, the income part is completely good. It's just the overnight stays. I have my kids literally a lot more than that. The only reason I can't get them.
You just told me earlier you don't ever get to see your kids.
No, listen, I get my kids when I call them, but I don't get them like every weekend or every other weekend. The only time I get my boys is when they sneak and call me and tell me to come get them.
Okay, but that doesn't sound like you get very many nights, because you'd have to show up and get them from the mom, and it doesn't make sense that you're getting a ton of overnights.
No, exactly. That's the only reason I don't get my boys, is because she don't let them come.
Okay, but the friend of the court through the prosecutor's office has to calculate by the actual number of overnights. I know you want more overnights. I know I've now given you 52 overnights a year until we get into something different. And I may ask the friend, Kent County prosecutor, to calculate based on 52 overnights, but up until now, that was a correct amount, and you didn't update your address. You didn't, and that has to be done, and you didn't object in a timely manner. I don't know what, there are certain rules. That's why I tell you better get an attorney, okay? Because there's certain rules that you're not figuring out here. Miss Bracy, is there anything that I am inclined to only ask Miss Rummel to redo the order and submit a new one based upon 52 overnights, which I have just ordered. Yeah. Okay. Because
that will help.
somewhere else down the road, that's what he's getting right now.
And I actually would like to, I don't want him to actually have any contact. He can talk to the boys over the phone because he's disrespecting me, being violent. He's talking stuff to me as we're leaving out of the courthouse today. So I don't want any contact. I don't want any contact with this man. He can talk to his kids over the phone, and I'm getting a PPO order out on him right now. So this is pertaining to me and my kids because this is too much.
Judge,
Yeah.
I'm by
What
myself
does that mean
here.
regarding, are you disagreeing with what I'm saying on a child support?
I am.
I am.
I'm asking you to for him to stay away from us until we have court orders, and until after the hearing because he's
Have a
threatening
court
me.
order now. You're going to have a court order of every other weekend.
Judge,
Okay, but
she is
he's
erratic.
threatening
I don't
me.
even know what is she talking about.
Mr.
She's here
Getter,
with her whole
let me
family.
talk to her. Quit interrupting. Miss Bracy,
Yes.
I've ordered every other weekend, okay? You can file objections to it all you want, but at this point, he gets every other weekend, all right, and every Wednesday. And if he shows up at your house and he's inappropriate, videotape it and bring it in, bring it in for whatever you want. It's pretty simple nowadays. So I've ordered that.
I have a video. I have a video today of him, and I'm objecting it. I'm objecting it.
Well,
because where you need to go object to that so we can go out here.
I entered the order where he's getting every other weekend right now. All right. And it will get to you soon. You can do whatever it is you want with that down the road. All right. You can object to it. You can, basically you can appeal it to the judge if you want. All right. And you'll have to take appropriate steps to do that. But right now he has every other weekend and Wednesday nights. And I'm going to just ask Miss Rummel to submit a child support order that gives him 52 instead of 24 overnights. And it will be starting November 1st, the order, all right, instead of...
Okay, he punches my son in his chest to discipline him and all types of stuff, so...
Ma'am,
yeah.
you can go to CP. I'm not here to settle every problem. I'm here just to enter certain orders. So, Ms. Rummel, with that, can you please submit a revised one for November 1st with 52 overnights.
So just an amended uniform.
And you're giving him more.
You're
giving him more hours.
The prior order is fine up till November 1. Okay. Good luck, everybody. Thank you. I'm sure we'll see you again.
Thank you.
Thank you.
Hello.
Yeah, we're done. I've adjourned. Amazing, but as I get rid of these, they're getting easier to find.
And the plaintiff has never logged in.
Right. All right.
Hello.
Mr. Gonzalez, can you hear me?
Yeah, I can hear you.
We have an interpreter here for you. Do you need an interpreter?
Kind of. Just to, to get better explained.
Mr. Guerrero, would you please raise your right hand? You solemnly swear to interpret to the best of your ability and not divulge confidential communications.
Yes, I do.
All right, Mr. If you need his interpretation, fine. Tell me if you don't understand something. Okay.
Okay.
Are you driving?
Yeah, I'm on park right now.
Yeah, because I can't do you while you're driving. Rodriguez versus Rodriguez. This is a motion, a ROPA motion filed by the father for his 10-year-old child, Joe Mary. Is that correct, sir?
Yeah, that's correct.
The requirements for a revocation of paternity are that it's filed within the divorce proceedings, of which yours has been done since 2018, or within 3 years of the birth of the child. You don't come close to meeting either of those. How can you ask for this? You don't meet any of the requirements.
Can that be explained in Spanish so I can understand it better?
Sir, all right. He needs to have filed within 3 years of the child's birth, and she's 11.
El tiempo ya pasó.
Or during a divorce, of which they've been divorced since 2018.
Yes, but they charging me child support for the girl that I'm not the biological father for that girl, and I am paying child support.
You are the legal father of that child because you never filed to get out from under being the legal father.
Exacto,
There
pues
was
lo que pasa
even
fue,
a ROPA motion, that you got out from being one of the children of the marriage, but didn't even request this back in
Ustedes,
2018.
they didn't explain that to me.
What? Who didn't explain it to you? That's not up to us to explain it to you.
nunca se me explicaron que ellos tenían.
Stop, so that the interpreter.
Pare un momento.
What?
He said that no, nobody explained to him at the time of the divorce. He just went for the divorce, but he never filed any motion for the children, or never, the children were never discussed. So he's been paying child support since then.
Yes, because he's the legal father, and I'm not allowed at this point, after so many years, to go back and try and determine that. It is not an excuse that he didn't do anything during the divorce, because in fact, there was a order back then that he was not the father of one of the other children.
So ese niño que
when he was married.
Pardon?
That happened when he was married, and that one never was put on the table.
Well, it was included in the judgment. It has been in the judgment for 7 years, and it is not open to re-looking at it at this point. He did not meet the statutory requirements for filing a ROPA motion for that child.
Como padre de ese niño.
And so he is the legal father of Joe Mary and remains responsible for child. Have to deny his motion because he did not fall within the statutory requirements. Thank you.
Okay.
Okay.
Thank you. Good luck to both of you. Thank you, Mr. Guerrero.
Thank you, sir.
No.
Este caso ya no se puede reabrir.
We are adjourned.
Y ya terminamos.
Por eso que el país está como está.
That's why the country is in the way it is.
Thank you. Thank you, Mr. Guerrero. Can you go and fix the country? Plaintiff is present, Miss Zugra, and we can't get the defendant. I don't even know if he's trying to log on or what. We've got people on the screen who are going nowhere. This is plaintiff mother's motion to enforce child support. There was a 9/22/23 child support order of $400 per month, and she says he hasn't been paying. Ma'am, the long and short of it is you have to go to the friend of the court to get that enforced. There's nothing I can do here today. You understand that? Ma'am, do you understand that?
I don't speak English, it's Spanish.
What?
I speak Spanish, no English.
Did you ask for an interpreter?
Yeah.
Is Mr. Guerrero still there? Can you tell?
It's still on.
Yes, Your Honor. Yes, Your Honor.
All right. Can you interpret for the mother, please?
Yes.
I have nothing to enforce, that she has to go through the friend of the court to enforce child support.
Since he was ordered to pay child support, he has not paid, not even once.
Yeah, and I don't know what she expects me to do about it. Ma'am, can you quit eating and drinking?
I got another appointment in the 20th of this month.
That's fine. They're gonna have to collect from him. They can collect through his work with an income withholding order or something. They will be your collectors, not me, because there's nothing I can really do. Until he gets far enough behind and the court issues a warrant for his arrest, then they can bring him in, demand that he pay, or go to jail. But you will have to seek that through the friend of the court. Mr. Diaz, are you connected here? Can you hear me?
Señor Díaz, ¿está usted conectado a la línea?
You're on mute, so I can't hear you.
¿Es a mí? ¿A mí es?
No, para el señor Díaz.
Oh, es que él no sabe mucho de eso.
Díaz doesn't know how to use the phone too well.
Mr. Diaz, can you hear me? Shake your head, yes or no. Sir,
Okay.
Can you hear me?
¿Lo puede escuchar?
Sí, lo puedo escuchar.
Yes, I can hear you now.
You understand you're ordered to pay child support?
Sí.
Yes.
If you don't pay it, the friend of the court's going to come after you. If you need to pay it, you've been ordered since September to pay it.
No estoy trabajando.
How much I do supposed to pay? I'm not working right now to pay, and also I am sick. I don't have money right now to pay.
You have a court order to pay $400 a month. That will continue until the court makes a determination otherwise, but you haven't asked for anything to be lowered or whatever. But you are going to have to pay child support, and right now it remains at $400 a month, and you'll be expected to pay it. Otherwise, friend of the court may come arrest you.
Estoy
Okay,
muy
if they want to
enfermo,
come
no
and look
estoy
for me and
trabajando.
arrest me because I don't have no money. I can pay with jail because I'm not working right now and I don't have no money right now.
Even if you go to jail, it doesn't take away the amount of money that you have to pay. So just simply pay it. Ma'am, your request to me to enforce child support, I only say is you have to go to the front of the court.
Para los niños.
Good
Y yo
luck,
no puedo
everybody.
hacer absolutamente nada por usted.
Good luck,
Eso sería,
everybody.
Buena
eso
suerte
sería,
a usted.
eso sería el día 20.
What, Mr. Guerrero, did she
That
say?
will be the 20th
I don't
of
know.
this month.
Good luck.
Yes. Buena suerte.
We're adjourned.
Ya terminamos.
Ok, gracias.
We're done.
Okay, thank you.
Thank you, Mr. Guerrero. Yes, matter.
Thank you, Your Honor.
Whitehead.
What was the name of that client?
Mr. Whitehead has apparently filed an objection to the friend of the court recommendation. The friend of the court recommendation was sent out on 10/18. He filed his objection. Let me see when it was filed, but he got it on 10/20. I'm not sure of the exact date, but clearly he filed it within the objection period. And objects to some of the information in there, claiming that he thinks every other weekend is not enough to establish a foundation, whatever. Because he has objected to the friend of the court recommendation, I have nothing other than to set it for an evidentiary hearing. Or what, are you objecting to parenting time, child support, and custody, sir? Mr. Whitehead?
Yes, your mic is like cutting in and out.
Well, you're breaking up. I mean, you're freezing all the time there. I think my connection's good, yours isn't. But so you're objecting to the recommendation of custody, parenting time, and child support. Is that correct?
Yes, sir.
Ma'am, I just have to schedule an evidentiary hearing for those matters. Then you'll have to come in and have a hearing in court. It will be a formal hearing in which everybody, if you're playing with fire if you do not have an attorney, because it will only be through legally admissible evidence that we will make those determinations in the front of the court. It's not anything else. So we'll see notices about the hearing. There'll be notices about when you have to exchange exhibits, when you have to exchange witnesses, when you have to file a trial brief and stuff like that. I expect everybody to follow it. And we'll see you here when we can. We'll set a 3-hour block somewhere. It will probably be after the first of the year. It's just what I have to do. If you object to it, then I have to set up an evidentiary hearing, and that's what I'm doing.
What do you mean I'm playing with fire? What do you mean by that?
Because if you come in representing yourself, you better know the law and the rules of evidence and stuff like that.
I mean, as far as me objecting it, I mean, that is.
You made your objection, and so I'm setting up an evidentiary hearing. It will be a formal evidentiary hearing, okay? That you must admit evidence through the rules of evidence. You have to follow what I'm going to send to you and all that stuff. All right? It just,
Do we both need an attorney?
I would certainly think so, but you're allowed to come in without an attorney, but you'll come in and do either of you have any idea what the best interest factors are? Because that's what you have to go through.
Yes, I do.
You have to go through an established custodial environment. You have to go through that placing the burden of proof.
I was just like really trying to request, just more parenting time than every other weekend.
Sir, you objected to this. This is what I'm hearing today.
Okay.
And you guys can agree on anything you want. If you don't, then you don't. So it's just not, you filed an objection. I'm ruling on that. And so we will set up an evidentiary hearing. Good luck. Well, you'll get notice in the mail at your address. Good luck. Thank you both very much. We're adjourned. Pardon me? Moore versus Seawood. This is a motion made by, I didn't hear what he said. The defendant, Mr. Seawood, who basically says, as I understand it, the two of you had a change of domicile hearing set for Monday, I think, to be heard by me. Mr. Seawood basically is saying you've agreed to settlement that includes something to do with child support and the change of domicile and everything. Is that your understanding, Miss Moore?
Yes.
All right, Mr. Seawood, what, between the two of you, what do you agree to? I mean, are you allowing the move to Atlanta?
Yes, on the grounds of child support being accepted at $150 a month for now, and the arrears being dropped.
Well, let me tell you about the arrears. I'm not positive all of them can be, only the ones that are owed to Miss Moore. I think there might even be, I called the friend of the court to find out. And the friend of the court seemed to indicate, although the attorney wasn't positive because she was at another meeting, that there might be something that is not owed to her and that you may actually have a warrant out at this point. You need to go to the friend of the court and take care of that. We will dismiss any child support that is owed to Miss Moore, because that's all that we can do. That's all you can even do, no matter what. Okay. And I don't know what the other is, if there's any that's owed to the state or anything like that. You'll have to go down and take care of that. Miss Moore, you have no objection to the getting rid of all the child support. Is that correct? Any money that you can get rid of. Is that correct?
Correct. Correct.
And you are okay with changing child support to $150 a month due to the change for you allowed to move to Atlanta, correct? I didn't hear you, but
Yes.
All right, thank you. Mr. Seawood, anything else that's the two of you have agreed to?
No, that is all.
All right, so we'll call the hearing off for Monday. We'll enter an order that allows her to change the domicile of the child to Atlanta, and that we'll enter a new child support order at $150 a month. All right?
All right.
Yes.
And we will put in the order that that Ms. Moore forgives all arrears that is owed to her. But I'm telling you, Mr. Seawood, you should contact the friend of the court, because there may be something that is still owed to the state, and you've got to take care of that. All right?
Understood.
All right. Thank you, everyone. Good luck. Take care.
Thank you.
I'm not sure who Peter Pumpkin is, but
I believe that was Sean.
It
No,
was.
that's-
I thought I changed it.
no.
There you go, I got it.
Versus Edgerly. Both parties are present via Zoom. This is dealing with 3 children. This is father's motion that says it's entitled custody. He says the kids left the moms and living with him. Emerson, the son, who's I believe 15, told him he couldn't live at the mom's due to the boyfriend. Says CPS is investigating. Made some agreements. There's a text message that was sent in that mom seemed to say dad can have the kids during the school year, as long as she had every other weekend. She needs summers 50-50. She filed a response, which mom wants the kids returned to her. Apparently there's an ex parte order at some point that was back in 7/28 that unless something was filed, the court's going to terminate it at some point. Claims dad's physically and emotionally abusive, wants to go back to 29, 10, 11, 12, and 14 for reports of him supposedly being abusive. That's so far past anything that's relevant. I can't tell you. Mr. Edgerly, this is your motion. What have you got to add to this?
I was actually able to look through and I wrote up a response, kind of like what I wanted to touch on her stuff, but everything she is touching on is pointless. It's hearsay, it's stuff like this. Oh, you've missed appointments. Well, yeah, I have missed appointments, Your Honor. And the reason I've done that is because they've either been told last second or the times and the appointments were decided for me. And then since I've actually rescheduled those and all the appointments have been taken care of, so that's not an issue. But the reason I'm asking for this is because all 3 kids have lived with me for 2 to 3 months. They go to school in Hudsonville, which is where I live. They get on the bus.
When did they start going to school in Hudsonville?
This year.
All right, so you enrolled them there and first started in school at the end of August?
Yes. Yeah, the beginning of this year, yes, sir. school
Ma'am,
year.
you
Yes.
live up in Sparta. The kids are not enrolled in Sparta schools. Is that correct?
I no longer live in Sparta.
Ma'am, do you have a video?
Yes, I can. Hold on just a moment. It's not letting me change it to video. I apologize. I'm trying to click on it here. Hold on. Okay.
All right. Where do you live then if you're not up in Sparta?
Cascade.
Okay, so you obviously don't live in Hudsonville, where the kids are going to school, correct?
Correct.
All right. So what is your objection? I mean, how can I?
Can I finish your? I wasn't quite there yet.
No, I got to kind of control this. I'll get to you.
Yeah, no problem. Sir.
Ma'am, the kids have been living with them during the school year because they're at school. Is that correct?
Yes. So the text message that he has is missing a large portion where I asked him to back up a little bit. The time that I moved was right around the time that the girls were starting school. There was a lot of big changes. They were having some anxiety about it. So I agreed to the transition period of during the school year. They could stay at his house during the school week and my house during the weekends, as long as it was signed by a judge and put in a legal agreement so I could not be railroaded later on. He did not include that portion of the text message in with what he sent to you. He did not agree to that and did not want to go through it in a legal way, and thus ended up forcing the situation where the kids are now with him because I made a rule in my household where the kids could not have cell phone use, and they were upset with this rule. He called
I
the
know all of
police.
that part. I know all the they were angry.
So-
They took off with him and all that kind of stuff. All right. I'm not going to try this case regarding custody at this time. Sir, can you sit down? It's kind of tough to watch where you're walking all over the place.
Yeah, sorry about that, sir.
But the bottom line is, he's asking for a change of custody. All right. And in order to have a change of custody, he has to fulfill at least marginally here for the court for me to set an evidentiary hearing as to have a preponderance of evidence of either proper cause or change of circumstance. Now, this tells me that the kids have moved in with him since at least September 1st or somewhere in August because they've been attending school there. That's different than what the order was in the past because I believe the kids primarily lived with you at one point, didn't they, ma'am?
No, we've had 50-50 custody for many years where, in which case, like before they stopped coming to my house, I was taking them to school in Hudsonville every morning and picking them up. This was not an issue of a matter of them getting to school.
Okay, but what I'm hearing is you don't deny that the kids have been living with him for quite some time now.
No, he has forced my hand. He took it upon himself instead of going through a legal agreement, which I was okay with as a temporary provision as we were going through the transition of moving and starting school so the kids would have more stability. And he forced my hand and took them all because I took their phones away.
And did you at any point go to enforce the prior order? The answer is no.
I talked to the police officer. I talked to the kid's therapist. And because of the things that Randy was telling the kids about me and my situation, I didn't want to push them emotionally where it was going to cause them more harm in this current situation.
Well, the bottom line is I cannot change custody on a Friday morning. All right. I can't change it. Mr. Edgerly, I cannot change it here. All I can do is set up an evidentiary hearing if I find that there's proper cause or change of circumstance. At which point, since the kids have lived in essence with you since the school year started, if not, I think that's a change of circumstance that would warrant an evidentiary hearing. It doesn't change custody right now. It doesn't do anything other than tell me that the two of you are going to be set up for an evidentiary hearing regarding custody. All right.
Your Honor, I would like to have my parenting time. I am not wanting
nothing that's been filed for this. What has been filed is for a change of custody, and his request, I'm not granting a change of custody, I'm granting a hearing on it. So that both of you will have to come in and prove whatever it is regarding custody. End of story. I cannot change it in this morning.
So does that mean he has to return the kids back to me on Monday? Because that is when my parenting time is supposed to start.
If you feel that it's being violated, I can't believe you've never filed a complaint with the friend of the court. I'm not enforcing anything. I'm not changing anything. I'm not doing anything other than setting an evidentiary hearing. If you think he's violating court orders, you can go to the friend of the court and seek their, advice, or you can seek their enforcement of parenting time orders. But I'm not changing anything other than I believe there is enough to have an evidentiary hearing to determine if these children should be with you or with him or joint custody or whatever. And we're going to have a evidentiary hearing in court. If you guys know what you're doing, you will hire an attorney for it, because we're going to have a formal hearing that's going to require following the rules of evidence, following law. It's not going to be just sit down and, you tell me that, last Thursday, somebody told me he did something. That's hearsay. You're going to have to do stuff on it. So if you think he's violating a court order, you can go to the friend of the court.
Okay.
What's not being said is, I will not return the kids until I am ordered to do so, because they don't want to go.
It is part of the court order already. Ma'am, you are violating the court order already.
Please,
ma'am, we're not here to argue between the two of you, because I got a lot of hearings today. Okay. You guys can call and talk and argue all you want. All right. The bottom line is they're the only court orders that are out there. Sir, if you're violating a court order, you're going to be subject to violating a court order. End of story. Your kids are not exactly, they're 11 and 12. They don't drive the bus. I understand Emerson's 15. They don't drive the bus. The kids are too young for that. The parents drive the bus. And so we'll see what happens. I'm going to set up an evidentiary hearing. My clerk will send out information to you. And I'd imagine we'll probably find some violations or something in the meantime. I can hold people in contempt or not, or whatever. That's just the way it's going to go for this point.
Your Honor,
because I can't do anything else.
I do have CPS backing on not sending the kids. So I will get that information, so that if you do decide that you want to hold me contempt of court because I'm not filing a court order.
If you go to the friend of the court, you'll use that, and they'll determine whether or not they should file a contempt proceedings against you in order to show cause and whatever. I'm not judging on that in the future, because that has to be through evidence. Okay. I'm not getting evidence right now. I'm just getting statements, and that's what I'm doing. I will set up an evidentiary hearing, because I believe there is enough that the kids have lived with you for the past 3 months or more in what isn't not according to the judgment. And I think that's enough to at least set up an evidentiary hearing. Good luck, everybody. We'll send out notice. Read your notices, because it requires certain things of you. You can't show up with nothing. All right. It's going to ask you to exchange witnesses and documents and file a trial brief and this kind of stuff. And I know people well enough to know they'll show up with nothing, and they aren't going to follow what the court is requesting of them. Good luck.
Thank you.
Both parties are present via Zoom. Thank you. The Miss Rosmarin asked me a question prior to this about was she be informed that it was on Zoom because she showed up. Apparently, I don't know what Mr. Rosmarin notified her of, whether it was Zoom or whatever, but both parties are here via Zoom. All things seem to have been corrected. So we will deal with the motion that has been filed by Mr. Rosmarin seeking. It says it's a parenting time request. Mr. Rosmarin, I've read through your motion, and it's not a parenting time request. You want an actual change of custody.
That's correct, Your Honor.
Well, then why'd you file it as a parenting time?
I guess I'm not sure. I went to the third floor, and they advised me on what to do.
This is a custody request in which you have to meet the Vadvarka standard to even get a custody hearing. Mr. Rosmarin has made several allegations in which he says there apparently is proper cause or change of circumstance. Anything you want to say briefly before I get on this, Mr. Rosmarin?
Yes, Your Honor. I'm just requesting an evidentiary hearing given a significant change in circumstances since our original order was filed in 2016. In particular, she has moved away from the child's school district, and I have moved within the child's school district, actually within blocks. As you're aware of, she has been held in contempt by the court for 3 times, and most recently in August, due to her,
giving you more time than you wanted, than you were entitled to. It was giving you more time than you were entitled to.
Exactly. So,
that's hardly a contempt that's going to go anywhere in this request. Go ahead.
So the bottom line is, my son is spending more time with me by her choice. She believes that is in the best interest of the child, that he is spending more time with me. Her sole issue is that she does not want the child support order changed for financial reasons. I mean, I provided texts where she has, asserted that it's in the best interest of our child to spend more time with me.
I read that, and I also read the whole document that it came on. And that's cherry picking the last line out of a statement where basically, if I were to read it into the record right before that, she calls you pretty much a bad human being. Okay, that was the crux of the whole thing. You cherry picked the last line, and yes, she did say they do need their dad, but she certainly didn't say that you were somebody that was a good dad.
Well, okay.
I read the whole document. You want me to read part of that?
That's right. The most relevant part is the fact that she believes that I should have more time with my son.
And that's why I'm part is the whole document. Okay. And you can cherry pick anything out of there and say, yeah, she says I should be involved, but basically she says you're not a very good human being to be involved with your kids.
Well, I find that surprising given the fact that she wants me to spend more time with my child. But, of course she's going to say that. She's going to personally attack me. But that's the point is that there's been a significant...
You have to prove Vadvarka proper cause or change of circumstances to get an evidentiary hearing.
She has moved away.
And I'm asking you if there's anything else other than you put in there, and I'll go through some of the factors that you put in there.
She has moved away. That was the basis for the front of the court to give her a disproportionate amount of parenting time in the first place.
That's a 6 or 7 year old document.
Exactly. And so there's been a significant change of circumstances since that 6 or 7 year old document.
Right.
That was the basis. She is no longer living in the child's school district. It is in his best interest to live close to school. He had 18 tardies last year.
How many this year? How many this year?
We have not had any snow yet. I'm not aware of how many he has had.
So there's none this year so far.
I don't know that.
There are none.
All right. Seems appropriate.
But Your Honor, if you look at the dates of when those tardies occurred, it was during the winter months. He's driving 20 minutes in the snow in the
response says it was the brother was driving last year, as I understand it, not him.
Either way, they were both tardy. So the point is that her moving away from my son's school district is adversely affecting him.
Hasn't so far this year.
It adversely affected him last year, and that's why it warrants there's a change of circumstances that was.
I didn't file last year then because he was being late to school.
I would have filed last year, but I didn't.
I know you didn't. Now everything seems to be corrected.
Your Honor, the reason why I filed right now is because it is in the best interest of my child. So I would have done it 7 years ago. I believe that the basis that the front of the court gave 7 years ago was an error. That it was.
Should have filed an objection to it because I'm not going to relitigate 7 years ago.
But that was the basis, and those bases have significantly changed.
All right. I've heard, ma'am. Do you have any response, sir? Sitting next to her, don't get on screen. I'm not going to listen, watch you move your head and do all this stuff. This is these parties. Ma'am, I read your response. Is there anything that you feel you need to add to it briefly? Because some of your response, I'll tell you in all honesty, this is just your decision that he's a narcissist and all that kind of stuff. And I don't care about that. I'm going to rule on Vadvarka and whether there is proper cause or change of circumstance to have an evidentiary hearing for this 17-year-old kid. All right. And if there's nothing more you need to add, you don't need to add it.
Thank you. Referee Fredericks, you read my response.
Yes.
Whether your opinion is it's wordy or not. I get that. I get that. I also, all I'm trying to do is raise my children. Tommy is 17 years old. He's 17. Nope. He's happy. He's well. He loves his dad. He loves me. There is not one thing that Chris can point to that I believe. I don't know whatever the words you said, the evidentiary. I don't know anything about that, but I cannot imagine, you do obviously, I cannot imagine there is one thing, not one, that Chris Rosmarin could say that would prove significant change for my 17-year-old. Yes, I don't live in East Grand Rapids. I live in the north end of Grand Rapids. I don't think that warrants change of parenting time. None of this does. And I think where my writing for you is, this has been 7 years. I don't know what else I can do to protect myself, to protect my children, and to stop this. And I get you see this all the time, Referee Fredericks. I get it. But I
see it through the two of you all the time, because this is not the first thing I've had here.
You know what? Wait a minute. I understand that too. But it is not, Referee Fredericks.
Don't tell me, wait a minute. I run this court. So
no, you do, and I've been in front of you, and if we don't stop this, I'm going to be in front of you over and over again.
I am going to make a ruling on his motion. You didn't make a motion. I'm going to make a ruling on his motion. His motion is a request to change custody based on proper cause or change of circumstance. Some of what he has stated includes that there was he wants to attack the friend of the court order from 2016, which probably was taken up within the court order itself. There's no change of circumstances by going back to a 2016 order. That was done. Parenting time, custody was set based on that. He states that contempt. She says the boys need excuse me, this is out of context. He talked about the boys need their dad more as they get older and stuff like that. Again, I've addressed the true full letter that you sent to him. Nobody's claiming that the boys shouldn't be with him. Nobody's trying to stop parenting time. He just wants to change custody from basically him having about 4 out of 14 nights to you having 2 or 3 out of 14 nights. And that's a significant change. There. Moving away 20 minutes is hardly anything of a change of circumstance or proper cause for this. Change of circumstance has to have a significant effect on the child's well-being. That's a change of life sort of thing. If she had moved 10 minutes away, 8 minutes away, I don't know, but she didn't move to Newaygo and the child is driving back still within 15 to 20 minutes of school. And it is still her responsibility to make sure that Tommy gets to school, whether it's him driving or whatever else may be. That does not provide anything. Mr. Rosmarin claims that he was 17 times tardy last year. Well, that was last time he was tardy was probably in June or before that. We're now in November. There's no tardies, and that does not provide change of circumstance or proper cause. You can't go back years and say, yeah, a couple of years ago he was tardy a lot. The bottom line is, I think both of you agree, isn't he doing well in school?
Absolutely. He has a 3.8 grade point average.
Well, that's kind of like, if it's not broke, don't fix it. Dad complains because the son shows up at his place day after day with his friends at noon because he lives close and his friends eat lunch there and stuff like that. That's certainly no proper cause or change of circumstance. That's a 17-year-old kid showing up at his dad's. And it sounds like, Mr. Rosmarin, you complain because they're eating your food instead of hers. He's just showing up there. And you want more time, and he shows up and does stuff during school hours and stuff like that. I don't know where that would be proper cause or change of circumstance. You brought up the fact that she'd been held in contempt 3 times. The last time, if I had it to do all over again, I might not have held her in contempt. She agreed that she did not follow the court order because she let your son go to you for a couple of days. And I said, okay, then let's make it so that she has to now feed him and send him back to her. And you said, oh, no, I just want to be paid for it, basically. And that is not, that's so far inappropriate. I can't even put it on the scale. I've never heard anybody say that that was a reason. No, hold her in contempt and have her pay me for the days that he was there. That's ridiculous. There's nothing that is adversely affecting this kid. He is doing good. He's getting to school on time. There is nothing as far as a change of circumstance or proper cause that has been provided by Mr. Ross Marin to even have an evidentiary hearing in this matter. As a result, I'm going to deny your motion and we'll enter an orders addressing that. Good luck, everyone. Thank you.
May I say one more thing, please?
No, we're adjourned. I don't want to, I just don't want you guys fighting anymore on this. And everything you say.
I'm going to have parenting time violations, Your Honor. It's going to continue.
That's you do what you want, and I'll deal with them as they come through. Good, everyone. We're adjourned. I'm denying his motion. Thank you. DP, Mr. Simpson, and is the defendant. Ms. Thomas is the plaintiff. How did you give her notice of this hearing?
It was served through the friend of the court served the papers to her. When was that? I don't have the exact date that they served it to her, but maybe last week they served it to her. I know I got a sworn letter that she did receive the letter. I got a sworn letter of that in the mail.
All right. Was it this week or last week she got it?
Last week, I'm guessing.
You think it was, do you think that?
No, it was last week that she received it. I think it was on about the 5th or the 6th. I can't recall the date, but it was a sworn.
All right.
Yes.
The 5th would be Sunday, the 6th would be, but all right, as long as you have a letter showing service by the friend of the court, because you don't have her address, I will assume that there's proper notice. This is your motions for child support and for parenting time. First is that, so there was just a child support order entered last month, 10/3/23, and you say I just can't afford it and all that. That's not an objection to get a lowered amount. I looked through the amount. It was, you said you make $16 an hour. It was based on $16 an hour. You said you have, I think you're given credit for having an additional child because you say you have additional child support order, and you were given credit for that.
Yeah, I got three other orders, and I'm making roughly I'm making $16 an hour on a 40-hour paycheck. I'm getting $1,000 taken out of my account, $500 for one child for him, and $30 a week for the other kids. So my misunderstanding is that for one child, I'm paying $500 just for who I'm here on today, Jake, paying $500 a month for him and $400 a month for 3 other children. So I'm trying to recommend, because I guess I'm paying some type of rearages or for the birth, but I was just placed on child support maybe a couple years ago because I took care of my child all the way up until the time that the mother wanted to press me on child support. So the issue I'm having is now that this support have went up, I'm bringing home roughly $900 a month, as far as, because $1,000 is getting took out for all 4 of these cases. So I just can't afford. I can't afford anything. I got my bills right here in front of me.
Sir, I'm not allowed to look at your bills or make a decision based on that. There's nothing in the child support order that is not taken care of. The fact that you got 5 kids, geez, no wonder you don't have any money.
No, I don't. The thing is that I have 4 kids that I take care of, that comes to my home, that I pay my bills, and my kids live with me on my own time because me and the mothers are separated. So I take care of my children well. So
you are given credit for that. You're given credit for additional children in the support order.
My thing is just the problem I'm having an issue with is that if I'm going to pay $400 for one kid, I got to pay $400 single for every other kid. I don't see why I'm paying $400 for one kid and I'm only paying $33 or $106 a month for another child. This child in Grand Rapids, I'm getting charged $500, roughly almost $500 a month for.
So you would rather have the others reviewed to see if you can pay more for them?
I want to see why I won't pay more for him and not pay the same for. I treat all my kids equally. So if they're going to take, I treat all my kids equally. So if I'm going to get one,
I'm telling you that there is nothing that you have cited.
I'm paying arrearage that I'm paying is on a birth. I'm getting charged a birth. All I'm asking is, can I get my support lowered back to where I was at paying originally before this hearing came about that I didn't know anything about? What
do you mean the hearing came about you didn't know anything about?
All I'm asking is, I'm here today on this behalf of this court to ask this court. I can't afford my bills with bringing home $800 a month. I can't afford my bills.
I cannot make a change in child support based on that type of an argument. I'm prohibited from it. You don't deviation factor.
So what is the next step that I take to try to, because I'm getting charged for
a change of circumstance that
I'm trying to
enables
figure
it.
out.
So therefore, I have to deny your request for a child support.
Okay, I get one more request, and this is all I'm asking. So why do I have to pay this? I'm right here. I'm just saying arrearage charge or $350 a month is for support for one kid. I just don't understand that, and I'm paying $103 a month for each single kid where I'm at here in Muskegon.
I suggest that you call maybe an attorney or something, because your request is not able to be granted at this time.
All right. Okay. So in reality, her kids, because the mother who I'm arguing with, she got 3 other kids and she's receiving support for these 3 other kids. Her 3 other children is making more than what I survive on throughout the whole year. I don't get to claim my child on child support.
I understand you're saying this. It doesn't come to the level of a change of circumstance that I would review child support. I have to follow the law. Okay, you can argue to me till the cows come.
I'm not even arguing. Okay, you're gonna make whatever decision you're gonna make anyway. So why
follow the law?
Okay, okay. So where I'm at as far as more parenting time, because I haven't seen my child since the last time me and you had this conversation. You was granting me every weekend. Then when I got the paper,
hold on. I'm prepared to deal with your parenting time motion. And what I have found was that the last time we were in here, I entered an order that said you were to get every other weekend.
Every weekend, me and the mother, we agreed to every weekend in front of you. We agreed to every weekend.
Stop!
I'm here on my behalf to try to get more parenting time with my child.
Mute him. All right. I'm not going to listen because I'm here to tell you about what I am ruling on the parenting time. I looked and it said, we issued an order that gave you every other weekend. I looked back at my notes and my notes looked like you were supposed to get every weekend, like I may have done wrong in that order. So I am going to go back and look at the transcript. And if in fact it was supposed to be every weekend, I will change the order because I made a mistake. And we'll enter that order. As far as whether you get the time or not, there is a court order that says every other weekend. I may have made a mistake at that, and I will do my best to take care of it if I look at the transcript of the hearing and it was every weekend, because my notes, though they are questionable, may say every weekend. That is what I will do at that time. So we'll issue the order on that. If it's supposed to be, I'll look at the transcript, and if I made a mistake in the order, we'll correct the order. As far as your parenting time, if you don't get it from her and it is a court order, then you go to the friend of the court for her violating the court order. That's the way this works. Thank you very much. We're adjourned. Tracy, I have to go back on that. Both parties are present via Zoom. This is a motion that is Dad's parenting time motion, is what he says. Excuse me, wrong. I did another case in between the two of you. This is the father's custody motion, which I don't really think is a custody motion. I think after reading through everything, I think he wants his parenting time back, but is going for custody. There was a judgment of divorce back in 15 that looks like it gave 50-50 to the parties, and that hasn't really been modified. There was apparently a problem sometime in the recent past with one of Dad's kids, not a party of this, not from these individuals, but somehow CPS became involved, and then these 2 kids, Lincoln and Delaney, became involved with CPS. And mother, I believe, came and obtained a ex parte order. Is that correct, ma'am?
Correct.
From Judge Hillary that also said you're to file something or it's going to be dismissed. Have you filed anything since then?
So unfortunately, I have not. I have it prepared to file. I was planning on filing it coming up, and then I was served with Stephen's motion in the mail last Friday.
Ma'am, that's not an excuse. Either you're going to follow the orders or not.
Yes, I am.
And so anyhow, it appears that what Dad says that CPS case is closed. He does acknowledge the mom, or I think acknowledges the mom has an ex parte, which actually I think trying to interpret what you're saying, sir, is that you want that ex parte taken away and you want your parenting time back. Is that
exactly? Yeah. Yes, that is what I'm asking for. The kids weren't even there for any of this stuff. So I don't understand. I don't understand where she's she had.
Is CPS involved or is the case closed?
The case is closed. I talked to him last week. He was closing it out. He said that day, and then I'm not sure what happened, but my wife talked to him 2 days ago, and he was closing it out. He said you did everything correctly. You guys are doing a great job. That's it.
Ma'am, what is your response to what CPS is doing?
I have not been notified that any case has been closed out. Stephen has provided no paper documentation. He also stated in his motion that CPS closed the case on the same day that they had opened the case. But then CPS came to my house 2 or 3 days later to talk to me and my kids. They clearly had not closed out the case.
What is CPS investigating?
They're investigating the kids weren't even there for it. It was our 14-year-old daughter had
But then the kids your kids did talk to CPS.
Correct.
All right. I mean, CPS talks to all the family and members and stuff like that. I'm very familiar with what CPS does, and they apparently talked to Lincoln and Delaney. And what is your take on what CPS is doing?
Right now, I don't know where they're at in their investigation. I have tried to contact them earlier this week. I have not heard back from them. I know the case had been transferred to a different worker. So I'm not sure where they are at with their investigation right now. I'm not sure.
What are they investigating?
Oh, what are they investigating? Alleged physical and verbal child abuse.
And
go ahead.
And they've done nothing so far?
I have 3 other kids still in the house. The daughter that was involved actually was back there that night. She was just a 14-year-old throwing a fit. And the plaintiff decided to capitalize on, stuff going on in my life. And that's all this is.
Well, all I'm asking is CPS obviously became involved. I don't know what, where, when. I don't have any information from it. This is like flying blind into a storm here, because she received an ex parte from Judge Hillary based on the allegations that were there.
Allegations she made, not any allegations.
I understand that they were made by her, but I also understand that CPS is somehow involved.
Yeah, they have closed out the case
until CPS. Well, about your other daughter or about these 2 kids? And how do I know that?
I don't know. I guess we'd have to call them and talk to them.
For this.
An investigation into what? There's nothing happened to my kids. Nothing. The 2 kids that we're talking about weren't there. None of this they weren't involved until Vanessa made them involved.
I understand, but CPS often goes and says, here's something happening to one kid. I'm going to interview the other kids to see if there are problems. And if those kids start saying, wait a minute, there's this and this and this problem, they can continue it, not just because of your initial daughter being involved in it. They will talk to other kids that are parties of your kids and her kids and this kind of stuff to see if anything's going on. And I'm trying to figure out what they've done. If they have closed the case and find nothing to it, then yes, I'll reinstate your parenting time. If they haven't, then I let them do their investigation. But ma'am, you were told by the judge before you had to file a motion to keep this going. And why haven't you?
No, it is my fault. I don't have legal representation right now. I did not know if once Stephen had filed his motion immediately after the ex parte was served to him, I didn't know if I could then go file the motion for the custody change.
I mean, if you're asking for a custody change and all this kind of stuff, it seems to me that the first thing you do is talk to an attorney, because this is a really big deal that your kids could or could not go to him or whatever. And I don't know, but in my life, that's pretty important. One of the most important things out there. Same to you, Mr. Tom. I don't know what's going on.
I mean, I don't think I need representation because I haven't done anything wrong. So I mean, I believe in the justice system. I believe that, you know, you guys are going to find out that nothing did happen. This is a nothing.
Tell me how I'm going to find out. What proof do I have anywhere? I got her statement that CPS is involved, your statement that it isn't involved.
Well, I mean, I'm innocent until proven guilty, correct? I mean, I haven't done anything wrong.
Criminal case.
Oh, okay. Well,
this isn't.
What would you like me to do in order to?
I'm not going to give anybody advice. All I do is sit here and call balls and strikes. Okay, and I get stuff thrown at me, and I get her saying yes and you saying no, and you saying I didn't do anything, and she's saying the kids are saying he's an abusive guy, and she's submitting police reports of firearms and all kinds of stuff from 2021 on things, and trying to basically make you out as kind of a bad guy.
Yeah, exactly. You got that right.
And I don't know, you know, ma'am.
My kids are not in any danger. They've never been in any danger. In fact, when all this was going down with our other daughter, I asked that they could stay.
Ma'am, do you have anything from a counselor or anything that says, oh, these kids are, you know, what evidence do you have that I should not reinstate it as long as CPS can always, if they think he's being abusive, they can file a petition and bring it in front of the court. Okay. And one of their favorite things is to not do that and just leave it to me to try and figure out what they're supposed to do. If he's a danger to their kids and he is physically abusive, they can make the kids a ward of the court and make him deal with it. But I don't gather that. So, I mean, right now, because the judge specifically said you had to file something and you haven't, and because I don't know of anything that is out there. I mean, you can still file for custody and stuff like that. But I don't have any reason to continue to, in effect, override the custody order from 2015.
Am I allowed to speak?
Yep.
We have the kids. I have contacted the school. We have spoken with Officer Wells at the school, Officer Lasota, the school resource officers. I can provide documentation. We have the kids set up meeting with Amy Tavares. She is the school counselor. She met with them just this week, and I have talked with her on the phone, and everything that the kids have told her.
Okay, but I don't have anything. You understand that?
Right. And I apologize. I didn't have time to get
there isn't anything.
Deny his parenting time based on nothing. Or that's what I'm saying.
There won't be anything either, Judge, because there is nothing.
Sir, I'm talking to her.
Oh, I'm sorry.
How am I supposed to do this with nothing? I mean, am I supposed to take your word that there's a counselor at school that said something that I don't even know what the counselor said? I'm just asking you that I'm sitting here with nothing.
Right. And I apologize. I was served with his motion in the mail last Friday on Veterans Day when the courts were closed. And then I had to immediately try to file my response before this hearing. I didn't have time to get more documentation from her. I did file with my response copies of the harassing text messages that Stephen has been sending Delaney and Lincoln all throughout the day.
Harassing, telling them I love them, miss them, can't wait to see them. I guess those are harassment. I'm not sure. I do miss them and I do want to see them. I'd like to see these harassing text messages that are
You sent
there.
a copy of your answer, ma'am?
I did, yep. And I have receipts for it and the certificate of service from the Postal Service.
Then you got a copy of everything I got. What's the problem? Sir?
I'm sorry?
You got, I don't know what the harassing text message.
This is news to me too. I didn't know she had harassing. There's no harassment. I've only told them I love them, miss them, can't wait to see them.
A lot of this is just
like maybe asking him what have I done? Why aren't you talking to me? Maybe why aren't you? Maybe questions like that, but nothing. I've never been mean, never spanked my kids even.
Man, I don't think I have any of these things, and some of the stuff you submit are holy smokes. Is this supposed to be his wife? Is Rachel? And you're saying that she was in 2011 had a drunk driving, and in 2019 failed to have proper registration? That's a big no. Big no deal.
That's because there's nothing. I'm sorry. I'll stop talking.
Yeah, just stop. Parenting time reports. Who generates this?
That is from the custody exchange website that I have used for the last couple of years.
So it shows he gets basically 50% of the time. That's based on information you give to them, right? What is the? I mean, I got some things here from Dad that are, hi, Mom, would you be able to pick us up tomorrow? This kind of stuff. I guess it's from this year. I don't know. Hey, buddy, did you guys not go to school today? No, because we were going to go to the bus stop in Dad's truck, but it broke down. I mean, is that what is that as far as the harassing stuff? And could you take them tonight from practice? I mean, this sounds like communications between the mom and the dad and the kids and for different things. Hi, Mom, we're having car problems on both cars and was wondering if we could go to your house for the week and get dropped off at school by you guys. That's from April. I don't even know. April of 22. That's a long time ago. What's that supposed to be relevant for, ma'am? Yeah, buddy, that's fine. What's that supposed to be relevant to? Do you guys work together some when there's some problems?
So when I had gone down to the courthouse earlier this week to file my response to his motion, I was told that in my entire response, I just have to respond directly to the motion that he filed and everything that he had put in his file. So all of the things that I had attached and everything that I had said was in direct response to that. He had made the statement in his response, in his motion, that he is him and his wife are the stable ones in our children's life. They are the constant stable ones. And the evidence that I was attaching, I was trying to show that he consistently does not maintain 50%. He consistently does not bring them to school on time or does not bring them at all.
That's from
that's not true.
March, and Dad has a layover tonight and was wondering if you would be able to pick us up and switch days tomorrow. I'll pick you guys up. Some of this appears to be what parents of kids are supposed to do. If they have some problems, they're supposed to talk to the other one and see if they can get it taken care of. That's a far cry from sounding like somebody is actually assaulting or harassing his kid.
Oh, I have the communication that he has had with the kids as well. I have the copy of that where it's him just texting Lincoln over and over and over multiple times all throughout the day when he's at school, calling throughout the day when they're at school, when they don't even have their phones on them. Lincoln telling his dad that he doesn't want to talk to him because he thinks his dad's going to try to guilt him. And then Stephen just continues to go on and on and on. He had told in there, he's telling Lincoln, I'll change anything at the house that you want. I'll make things different. Why don't you want to be with me? Are you forgetting about me? Do you not love me anymore?
I never asked him if he didn't love me anymore.
regardless? What's the purpose of all of this? I mean, why am I going to deny the kids going to their fathers, ma'am?
Because they are afraid. They have stated to me, they have stated to Bailey Rogers through Kent County CPS, they are afraid to go. They are afraid for retaliation for talking to CPS because Stephen refused to give parental consent to Mark Allen, the original initial investigator. He refused to give consent to talk to CPS. That's why he then contacted me and I gave consent.
Okay, but what makes them think he's going to retaliate against these kids, and what's he going to do?
I mean, I can tell you what they've told me and what they've told CPS. I don't have any paper documentation from CPS because they're still investigating.
You say they're still investigating, because that means the case is still going open. Otherwise, if they're just filling out the report, closing it out, that's something different.
Okay.
All right. And I don't know whether they are or they're not. Because he says they're closing the case with, I guess, are they substantiating anything, sir? If you even know what that means.
No, they told us we did everything correctly. Everything is good. We've not missed an hour of time with any of the other kids. They interviewed our daughter, and I didn't want to involve the kids, the other two in it. They weren't even there. I was trying to avoid all of this, and now she's brought them into it. She's trying to capitalize on us having a hard time with a 14-year-old. That's it.
Is Lincoln 13? Or
He's
14?
He's 14.
So you got two 14-year-olds?
No, oh yeah, 14-year-old, yep. And then another 14-year-old.
It's his stepdaughter.
I understand. It's his wife's daughter, as I understood it. It appeared that was the one who started everything going, and that it was not your kids, or your kids weren't even necessarily there.
Right. And we didn't, none of us on, the kids or I did not find out about it until Sunday night when Stephen called Saturday night while Lincoln was at his friend's house for a sleepover, and Stephen called Lincoln and told him about everything about CPS and not to talk to CPS.
I did not tell him to not talk to CPS. In fact, I told him that CPS was going to call him, because at first I told him, yeah, because I have nothing to hide, go ahead and talk to him. And then I decided later on, I said, you know what? They don't need the hassle of all this. They shouldn't have to go through all this. And Vanessa decided to bring them into it. I was trying to protect them from it.
Vanessa didn't decide to bring him into it. CPS asked to talk to him. All right.
Sure.
That's the bottom line, because when they're investigating a family, they investigate all of them. So it's not, I'm not going to blame her because she, quote, brought him into it. All right. You're making that giant leap there that's not there. Because I am stuck. I have no idea what I'm supposed to do with this, other than to set aside the extended parenting time, because I don't know that you're not telling me that there's anything that's happening to these kids. They aren't, I don't understand what CPS has to say about these kids at all. They might say something about the girl who was 14. I don't know, but the judge's order said, and that was from back in much earlier this month. And it appears that there's no reason to continue the judge's order. However, it is the judge's order, and I don't very often get rid of his orders, because he makes the determination based on these things. I'm tempted to adjourn this to my next motions for each party to bring in whatever they want to show. If CPS has dismissed the case and says everything is fine, I'm going to reinstate his parenting time. If you can show anything different, ma'am, I'll take a look at it. But at this point, it looks like in the near future, I'm going to set aside the judge's order unless I have something different, but I don't have anything from either side right now. He just says CPS is closing it, but I don't have that information. You say it's not closed, and I don't have that information. So what I'm going to ultimately do is I'm going to adjourn this for 2 weeks, and at the end of 2 weeks, come back and without any significant proof or proof that CPS has dismissed or something, I'll reinstate dad's parenting time if that's appropriate at that time.
So I can't see my kids for another 2 weeks, is what you're saying?
That's what I'm saying. It's his order will remain in place for 2 weeks. Until I can get more of a handle on it. We'll have you back in 2 weeks and make a determination.
Referee Frederick, may I ask you a question?
Yeah, I might not answer it, but go ahead.
What kind of the things that my kids have been telling me, the reasons that they're afraid, what they think is going to happen. I guess I felt like me just saying that, right, telling you everything during this hearing, that's just my word, that I'm just saying that that's what they're saying.
What makes me think that their kids are so terrified that he might, because they talk to CPS, that he is going to retaliate? All right. I don't know of anything in the past. He's had 50-50 since 2015. All right. Basically 50-50, even if you have a little bit more. But there hasn't been any of this stuff in the past. The kids haven't shown up at CPS abused. They haven't been, these are parents that are sitting here trying to figure out what they're supposed to do. And because are you telling them, yeah, your dad may do that to you? That's as much of a possibility as is the possibility that the kids are worried about this. What do they show up? I don't know that they've ever shown up beat up from the dad's house or horrible things have happened to them. This is just something that seems to come out of nowhere. And now they're afraid. Aren't you telling them you don't have to be afraid? Your dad's not going to do anything to you. Do you tell them that, ma'am?
Before CPS had got involved this second time, now I was not aware of any type of physical violence that was going on there. I was not aware of our kids seeing anything going on that by Stephen or Rachel. After Stephen had contacted Lincoln on Saturday night and told him about CPS, Lincoln told me that CPS was involved. I had conversations with them. Lincoln and Delaney, I told them that they can talk to CPS. These are the good people. They can trust them. And then once Lincoln kind of realized that, because Lincoln stated that he was afraid that he would talk to CPS and be honest, and then that his dad would find out what he said. I told them, I said, you don't have to worry about that. You don't have to worry about that. And that is when Lincoln and Delaney both finally started opening up to myself and my husband, Matt, and told us about what has really been going on there. Just the week before they had came back to me, they had told us about an incident where Delaney was supposed to be sweeping and she missed a spot, and Rachel was screaming in her face to the point that Delaney started crying. Ariana tried to finish sweeping up with the broom and Rachel started hitting her with the broom. That was the very last incident. And then it just went on and on and on with all these things that they had been witnessing there.
None of that's true, Judge. That's never happened.
So are your kids making that up?
I didn't hear them say it. I think she might be, because I can't imagine they would say that. It's Thanksgiving. It's Thanksgiving coming up. I'm going to miss out. They're going to miss out on family, because of they're not in any danger. They've never been in any danger. It wasn't until she saw the CPS
they're
case.
Not in any danger other than you telling me when CPS is involved with the case.
All
what
I
is
can
the
tell you
CPS worker's name and number?
Name and number.
The CPS worker that came to my house.
I don't know. Who's the CPS worker involved with this?
Yes, I have all their contact information. So the current, the worker assigned to the case, his name is Mike Ectona.
Yeah, Mike. And I would love for you to talk to him. He's the one I've been talking to.
Man? What's his number?
542. And then I also have the contact information for Bailey Rogers, who was the CPS investigator that came to my house.
But Mr. Ectona is the one who is in charge of this, apparently?
Mm-hmm.
I'm going to adjourn this for 2 weeks. In the meantime, if I talk to Mr. Ectona, and if I do, and he tells me that the case is being dismissed and there's no substantiation, I will probably have my clerk contact you and tell you that I'm going to remove the judge's ex parte order before then.
Thank you very much, and
But
I hope you're able to.
I don't know that that'll happen. All right.
Well, I hope you're able to get in contact with them today. This is my parenting time again, should be today, picking them up from school. I would love it if you're able to call him. Please call him. I miss my kids, sir.
I understand. I will, I can't promise what'll happen, but I'm gonna look into it a little bit. It's not my job to look into and investigate cases, but because I'm getting two different words.
Well, I appreciate
We're
it.
adjourned for 2 weeks unless you get something different. Good luck, everybody. Thank you.
Thanks.
Thank you.
We made really good progress up until then. I obviously lost my mind. What other one?
Am I on?
Yes, you are.
Okay, thank you. I just said my audio wasn't working.
Did you send this motion to Mr. Bauma?
I did. He has it, and he's been reminded, and I talked to him about it yesterday and asked him if he was ready for court.
Yeah.
Yes.
Bauma has filed a couple of motions to the court. The first being for reconsideration of my prior order that basically ordered her to pay $6,000 to him. Ma'am, 2.119F says you have to file a motion for reconsideration within 21 days, which apparently you did, of the order. No response is required or asked for from Mr. Bauma. However, there has to be palpable error that the court or the parties were misled and different disposition of the motion would result from the corrections. I don't know what. Ma'am, I gave you time in court to put on, and it was one of the most disorganized things that I've seen in a long time of what was supposed to be paid. There's a real specific list of items that he is supposed to pay. Now, your thing comes up, you even talk about rent, mortgage, daycare. That wasn't supposed to come out of any of this kind of property settlement.
The pages, if you read through that whole divorce work court order, it is very well defined and explained in the sentences. If there's any childcare expenses, we are to divide 50-50 in that.
Childcare expenses are to be that of the person who incurs them, as I recall, because I did read through it. And even if it is supposed to be divided, it's not anything to come out of this property settlement, the sale of the house. It doesn't say anything about that. Okay. If I read through this judgment and follow it word for word, the first thing I read is the children shall attend Thornapple Kellogg School.
Yep.
Okay?
And you keep throwing it at my face, sir, but we discussed it. It's on camera in your office. I was misinformed.
Okay, why don't you talk and let me know when I can?
I'm sorry. I'm frustrated, sir. I'm hurt. I'm like, there's so much going on right now. I feel you have not given me a chance from day one. I shut down. I have not been able to speak up because I just feel cornered. There's so much I haven't spoken up on. I'm suffering. My kids are suffering for it. Like, there's a whole other world of stories there, and I just don't know how he keeps winning. To do anything for these kids. I understand there's great fathers out there that deserve their kids more than the mothers out there, but this man in this situation does not. I only say that because I did everything for those kids. He was around to convenience himself. He didn't raise them growing up. You can ask my children, even one by one in a separate room. They will tell you who did everything and everything for them. They are my life. I would have never moved down here. I swear on my life, if I knew that was what I was doing was wrong, I could not bring them down here. I am trying to figure out now. I am even considering trying to get back up there because I want my kids. The total balance of the payout, I listened to you. I understood. I went back. You told me I have to go back myself to get my money back to you. I have to do that. That's what I did today. I broke down what it does pact. I dismiss any extras that he should owe me. I don't care anymore. I just want that to be done. I want to be done with him. I didn't add those in this total. This is total legit. I have bills to prove it. I have everything that owed in this court order right now, what he actually owes me. Yes, there was a miscalculation. I misunderstood. It wasn't misunderstanding. It was a typo on my lawyer's part, which I am suffering for too. I'm out of money on. It sucks, but I can't do nothing for. But this stuff here, I have proof on that he owes me. And then the other thing I went on, with his parenting, my kid still is sitting at home by herself every night. He's still working that second job at night, so she's not getting dinners. He feeds her I talk with her and I ask her questions. He fed her dinner. He feeds her once a week, and then she gets the leftovers from his weekend when she comes back there, like for my weekend. And then he works his evening. She had an ear infection last week, and she came to my house with. I found out on Saturday night. She had a toothache all last week, the week before, and she had an ear infection all week. He didn't take her because he didn't have time because he had to work. I myself had to schedule those appointments to make sure my kid was taken care of to get seen. He ended up, I told him, I said, if I schedule this appointment for a day that works, I said, she is hurting bad. She needs to be seen right away. I said, can I make it for Monday? He told me in the text, yes. I schedule it first thing. As soon as I wait for them to open, I schedule a doctor's appointment for her to be seen. And he ends up canceling it because he's missing work the next day for the evening to get her fitted for a uniform. He said he can't miss 2 jobs work pay. So he rescheduled it and then took her out of school still Monday because she was hurting so bad. But he told me he can't reschedule it because she wasn't hurting. I didn't even find out my kid was pulled from school on Monday because of the pain. And he was telling me she was better. So then I find out that she was taken out of school Monday and he canceled appointment still, had someone else get her. He couldn't even leave work to get my sick kid. And then he sits here, they drop her off at home in pain. He reschedules her appointment for the next day. She has to miss school now for 2 days in a row because of this ear pain because he couldn't get off his second job. Like, that's not acceptable, sir. And it's so bad now, she had to have a follow-up for her ear, and then she has to go see a specialist. And on top of that, her tooth pain, they found out was molars that haven't grown in that she has to see a specialist for. He didn't schedule the dental one yet for the specialist. He didn't give me any paperwork. He ended up at the doctor's while he was there, took me off as a primary contact and switched it to his name. So I had no notifications or anything coming to me anymore. Like, I didn't even know she left school. Then yesterday I find out I'm FaceTiming her and this is one day off and I'm like, where's dad? Because she's sitting there. I could tell she was lonely because she called me. She calls me when she gets lonely there and talks to me and I know I feel it. And I'm like, where's dad? She's like, at his girlfriend's house working on her TV. And this is at 8 o'clock at night. The one day he had off with her, like he could have made dinner and actually gave her the time. Like, there's no parental control there. There's nothing. And that's one thing you said he would have to do and he's not doing it. He can't even take care of her, sir. That's why they are my priority. And like I said, I'm trying to figure out a way to get back up there to move. I'm trying to find a place because I'm their mom. I care what's going on. Sorry.
Your daughter
And
wants to move back with you?
Huh?
Your daughter want to move back in with you?
She said she told me this past weekend she wishes I was up there so she could live with me.
Ma'am, I can't even understand what you're saying.
She said she wishes I was up there this weekend because she could live with me. She's stuck on school. She's willing to go through it for school. And that's what kills me, and that's why I'm looking for a place up there. Sir, it sucks. It sucks.
Yes, it does.
I made a mistake and I regret it and I didn't mean to do it intentionally though. And I understand that what I did was wrong.
Intentionally do it. I'll accept, but you did do it, okay?
I did.
I accept that you say I'm sorry and stuff like that, but the only solution is then I send her back down there where she doesn't want to go to school.
I know.
And you knew that she wanted to go to school when you moved down there. Okay.
Yes.
And you knew that would affect her softball and stuff when you moved down there.
I didn't know that part.
Well,
she told me that part after we started, when I found out about the papers, when I got served papers, I'm like, what are you doing? She said, Mom, I can't play basketball or softball if I'm down. That's when I found out. That's when I called the school and they told me yes. She would have to take a year off. That's when he explained to me she would be fine as long as she stays committed to travel ball. That would not affect her.
Well, that wasn't the word that I got. And
I know he didn't tell my daughter that either. I found that out, and then I put him on speaker and talked to my daughter about it with her. And I said, and I informed him of that. He was aware of that. And I asked why he didn't tell Kenzie that. And she heard it too. She could back up that story. He didn't tell her that misinformation that he already knew. It was more to get her, convince her even more to come back there.
So I'm asking, you filed 2 motions, one for reconsideration, which you really didn't provide any information for me to reconsider as far as the numbers that should come off. I didn't know.
You
just say daycare, which I'll read you the child care expense. The child the parties shall each be responsible for all child care expenses utilized during his or her parenting time. It's not split equally. It's used during, you're responsible for that. So you tell me that he's responsible for 50% of it, but this is in the judgment.
These were the visitation days that were supposed to be, he was visitating, that he was actually going after school to their house and staying until 6:30. Those are his charges. So the PM visitation days were his side.
I'm just telling you that this is what it says and this is what I have to enforce.
I will eat it. I don't find, that's fine. I don't want to go back and forth.
I'm not trying, I know you think I'm against you and I'm not.
I just,
the only thing that I'm for is for your daughter, quite honestly.
No,
I mean, the two of you have gotten to me to the point where you bother me. Okay.
I just want to be done with it. I've tried co-parenting. I tried even inviting, like trying to do things with him, like even like offering stuff, like trying to build a relationship with him. There's no relationship there. That's the other thing. Like, and I try to ask him about what's going on, like school and all that, and he will not respond to my messages. He talks to Kenzie and expects Kenzie to tell me. Like last weekend, I found out when I picked her up for Friday for my visitation, he told me Kenzie needs to be back home by 1 for a fitting on Sunday. I said, what? Why didn't you guys tell me this? I'm just supposed to drop everything and do that? And he said, I told Kenzie to tell you. I said, well, that's not Kenzie's job. That's me and you to communicate and work around. Yeah. And he said, that's her fault. And left it at that. And that's why he had to.
It's not her fault. All right.
No, I know it's not. And I try to communicate to him and he don't respond. So then I have to go and ask her, I'm like, can you tell your dad, please, to respond to my text? I shouldn't have to do that either. She shouldn't be involved at all.
No, you shouldn't. He should be involved and only him involved. I understand that. Okay. And what your other motion is, to enforce or something, the order. And I'm saying, what do you actually want a motion to enforce? I mean, are you saying, yeah, I'm going to issue an order that he has to be a good dad? Because that isn't going to work. All right. Apparently, if he's not a good dad, he's not a good dad. I don't know whether or not, you got to understand that I only know the two of you from on the screen. Okay. And all he ever did was make a motion. His only motion was to get his daughter back to the school that you guys agreed to. That was the only thing he really did. Okay. And if the daughter would come back and you came back or anything, absolutely fine. He was making the motion that said, I want her to go to school where we agreed that she'd go to school. If you, like I say, if you'd been around and if you could do the transport or anything like that, it would have been over and done with in 10 minutes or 5 minutes. Okay. But it couldn't. So I had to have a hearing and I had to talk to your daughter about it twice. Okay. Because as a junior who I don't have any idea if she has ability to get a scholarship, but both of you told me that you can't really afford to pay for college and that it'd be great if she could get some kind of scholarship because that's probably the best way she's going to get to go there. And she wants to go there. Okay. And if your move hurts her in the possibility, that's not good. And so she is your daughter just wants to go to school where she did and play softball and try to get the best. If you were to come back here, there would be no question that there'd be no change. I was even I don't even want to change custody or anything to him. All I want to do is get her to school. And I give you most of the time that's not in school. Okay. That's all I wanted to do. Get her to school.
Well, the other thing, I was supposed to have him for Halloween and he's kind of taken advantage of this custody thing, which I've never done. I've always, even on my days, my visitation, I always ask if you want, he's asked to have him and I have given to him no question. It's our kids. There's no mine or yours. If I'm not doing anything, nothing planned, sure, it's your kid too.
That's fine.
Nothing. And he told me I couldn't have her for Halloween. It was my thing. I let it go because I'm not going to fight about it and I don't want her to do that, but.
You mean you were supposed to have Mackenzie? Okay, but first of all, she's 16.
I know, and that's why I wasn't fighting too.
Second of all,
I'm just worried future.
When was Halloween? Wasn't it a Monday or Tuesday?
Yeah, I was gonna take Sophie up to go trick or treating up there with her.
Oh,
with Kenzie, so they could go together.
All right. I thought you were gonna take her home and drive her back.
No, I wasn't doing all that. No, it was school night.
All right. What do you?
I'm worried about that later. Like, and that's the other thing. Well, when I first talked about Chill, I was like, first I was gonna come get her after school Thursday because she didn't have school Friday. And then but we live out in the country and I thought about, and that's when he told me, no, it's my visitation. It's my week.
What's happening with Thanksgiving?
No, with Halloween, I was going to take her overnight because she has school.
I understand. Halloween's gone. All right. I can't.
Yeah.
I'm asking who's supposed to have Thanksgiving?
We are by the Ottawa County. That's what sucks is why my lawyer gave me Ottawa County's parenting time, because I don't even know where to get that. All I have is Kent County is what they sent me.
So you
But
don't
she put
have
my
any
court
idea
order.
who's supposed to have her for?
You didn't put that in any of my paperwork. Nothing. I don't know. Like, that's the other thing that's frustrating. It's like she gave me it. I'm not in Ottawa County. I'm in Kent.
I know, but Ottawa County is even used in Kent County
Is
because
it same thing?
because they have set out an order and people like to follow it. All right. I don't know what the reason is, but I had the Ottawa County order for somebody who's living in Flint the other day. All right. One person's here and one person's in Flint. And I'm trying to find out what.
He sent me something long time ago, so we knew. But I wish she would just put where can I find? It's whatever the father has off years or mom has even. Okay, so I have them even years and he has them odd years, but it don't say the split holidays, so they're divided on how that works. I don't even know how to get to it.
You got a lot of money from a house settlement. I don't know why you haven't talked to somebody besides me about this.
Me?
Ooh, yeah.
I got 14 out of it.
Well,
after all of our stuff was paid off.
Seems like you could hire an attorney to give you some relief.
I had to pay my lawyer fees for divorce and mediation. And everybody I owed in the time I was borrowing money when he was taking it.
I mean, I don't even know that I have the judgment in here that says the Ottawa County. I'm trying to figure out what's going to happen.
I tried looking online and I don't know where to go. I'm not really that great at electronics. I'm kind of more professional.
See, here's what you can't do. You can't ask me to find it, okay?
No, I know. I mean, I'm asking you directly where I go. Do I just go to MI government, Michigan government site?
I don't know
I just don't know why my lawyer didn't put that in here.
But again, this is the kind of stuff that
I know. I need to get together. I know, sir. I'm sorry.
You've got me trying to figure out what your judgment says when you had an attorney to do this.
And she sucked. She charged me a lot of money.
I don't know. Parties for Christmas 2023, the plaintiff shall have the children on Christmas Eve and the defendant shall have the children on Christmas Day. The parties shall have a rotating holiday schedule per agreement. In the event there is a disagreement, they shall exercise holidays per the Ottawa County friend of the court attached to this judgment.
But there was no attachment.
But I don't see it attached at all.
She didn't either. She didn't attach it to mine.
Right.
She did a lot of things. And a lot of that money was owed, sir, because he got fired and he was taking his own unemployment and put it into a different account. And then he also was taking my checks and we were so behind. We almost got eviction. We got eviction notice a few times. So then when she had us use his retirement fund, which I didn't feel fair either, but to get caught up instead of cashing out 50-50, we ended up putting all that towards the bills.
What do you want me to do here today?
I just want my money. Like, I'm going after what's legit in this work order that is supposed to be taken out. I'm just asking for that recalculation so I can have it in front of me exactly what is owed. And I exactly have the bills in front of me as well, that what he owes me and what I've already paid out for him.
But I gave credit for a number of them.
I don't know where we were throwing numbers, but that number didn't add because after every deduction that is taken out, when I did it in my head and I sat down and did it again over and over, we each got $18,449 after the joint bills were paid off that was supposed to be in this court order. I didn't even add in this total either. I ignored March's rent. It's better a loss. It's a headache to keep fighting for. I don't care to deal with it anymore. I'm just letting him have that. Like, go, whatever. I am doing from basically April or May on of what he owes me. It's a clear.
But there is only certain things in your judgment that I can give you.
Yes.
So in other words, if you say he was supposed to pay some of daycare, that isn't out of that number, okay? There's only things within that I can give you and follow the judgment. Otherwise, I'm asked to make up the answer, okay? I'm asked to say, go over here and there. And the courts are really, we don't mess with property settlements, okay? Custody, parenting time are always an issue. But as far as parenting, property settlements, once you sign it, it's carved in stone. All I do is enforce what is carved in stone. And the best that I gathered when you were in here is I was giving you, and he was giving you credit for some of the things that you said belonged there and didn't belong there or whatever. And we came up to a number that I thought was correct. Now you're telling me that in a motion for reconsideration, which has to provide me that, yes, this is what it is and you were misled, and you just have no clue what the motion has to include. All right. You're shooting from the hip, and I understand, and I'm trying to be kind, all right, and considerate, but I also have to, even if you say he's a bad guy, I still have to follow the order because that's what you guys put in the order. All right.
Yeah.
And
these calculations are from the order, within the order.
But we already considered them.
It wasn't when I agreed. No, it was what you were saying had to be like that, and I had to go back for what is extra owed. Like he still has lots of owed, like the cell phone. I got the payoff for the cell phone right in front of me now. I have each month and it says in here he was supposed to have Kenzie and him on a different line. I have text showing me trying to get him off my line and him telling me can't do it yet, not yet, wait, putting it off still. To this day, I do not have his phone. He has not paid it off yet either. He has not returned a phone to me for me to even exclude those payments. He kept the phone. Not to mention, my daughter's phone is still in my name. I'm still paying her phone bill, and his monthly payment for that phone he still has that he's never paid me yet on. So these go back from, I even excluded April's monthly bill because I'm starting from scratch from May on for when this was all supposed to be taken care of to carry out why it's still going, and he still has not done anything to get it switched over. He owes me $115 a month for a phone bill because our phone bill was $275. I did $115 a month from May to August, and then August I got that phone bill down even more, so it went down to $110. I got it even more the next month, and that was with October when I shut his off, but I still had to pay his charges for his phone, you know, the bill of the cost of the phone, and I have my daughter still on my line. So for October, November, it went down more because of it. His line was no longer active, but yet my daughter's was, and I'm still paying for that phone off that he has of his still, and my daughter's phone.
If the house is not closed by the end of March 2023, defendant shall pay to plaintiff 1/2 of the mortgage and 1/2 of the lot rent and utilities, in addition to $100 per month for his cell phone plan until the home closes. If defendant does not keep up on these payments monthly, he shall pay the total reimbursement to plaintiff with the proceeds from the house sale. So
and that he didn't pay that. He didn't pay me May's lot rent.
That's what it says in there that I have to enforce. The second is the parties shall split their cell phone account and each shall be responsible for his or own cell phone expenses. To do so, plaintiff shall pay off the phone loan with his proceeds from the sale of the marital home to facilitate splitting the account. That's all it says right there. Mm-hmm. Nothing beyond that I'm going to enforce. Okay. So I don't know what you're saying.
I have, and then the medical bills, there's medical bills from past before our divorce was finalized, which everything was supposed to be all that before our divorce is final.
It says plaintiff shall receive the total of $1,800, which represents money defendant owes to equalize the stock value and the automobile and stuff like that. Then there is shall divide the remaining profits equally, which represent his portion of the late fees in the event that he does not pay, blah, blah, blah. There is something in here. Oh, the party shall pay all outstanding medical debt from the total proceeds of the sale. That's all it says. Party shall pay the total proceeds from that.
And the phone until they're switched over, all the proceeds from the marital splitting account.
I just read you exactly what it says. I'm not going to interpret it in anything.
Yeah. That's all I have. That's all I'm coming for is this. What I'm asking for is I took out the daycare, took out all the other extras. I don't care anymore. He took enough on me. I just want what is in this papers, like the bills.
How much do you think he owes you?
I have on here, after I did the calculations of everything, it's going to be $3,101. It's between the phone bills and his phone, the rest of his payoff on that phone of his that he has, and then on top of the medical bills that were kept coming. And then we have here my mortgage from May.
So have you paid him any portion of the 6,000?
I paid him all of it.
You paid all $6,006?
Yep.
All right, what else do you, well, I gotta get on to other cases. I mean, I'm spending my life with you. What
Sorry,
other
I don't
relief
wanna
do you
do this
want?
anymore.
I mean, if I set a hearing to come in and give you the opportunity to show what he may owe you, all right, and I give you a 1-hour hearing sometime because you've got the evidence that he hasn't paid what he's supposed to, and we'll come in and we'll hear it. What else are you asking for?
I want just that money, and then I just want my kid to be taken care of. Like
Okay,
he told us that he was gonna be
ma'am,
there.
stop for a minute. You want me to issue an order that your child is to be appropriately taken care of? Because that's a useless order.
I mean, if he can't do it, then there's no business there.
Are you moving? Do you want to?
I'm trying to look for a place up there, right? It's hard. It's so hard, sir.
I know it is, and I'm not trying to make your life harder.
I make 18 an hour.
What?
I only make 18 an hour. Like,
I know.
Out there.
But you did get money from your settlement, but I'm just telling you, I'm asking you, what do you want from me?
I want my kid to be taken care of is all I'm asking, and just giving me what I owe. Like, my two priorities, like.
Okay, but what am I supposed to order for your kid? There's no, I mean, I'm not ordering that he doesn't have to take care of her. I don't know what you're saying. Yes, he's got to take care of her.
He was told not to, he couldn't do that job only when he didn't have the kids. Like, on the weekends he'd have kids, and he said, I can do that. Like, but he didn't do that, sir. My kid is home from school by herself. The minute she gets home from school, she is by herself until 10:30 at night, every night.
And is she complaining about that?
No, she's bored. She calls me bored. I'm talking my head off. Like, you can tell she's not going to tell me because she knows I'm going to go to court.
Well, you are in court.
I know.
Well, I don't know what I'm supposed to do. I'll give you a 1-hour hearing based on the some type of the financial, but it better fit in, because it has to fit in with the judgment, not just with what you think it should be.
I do. I got it.
See, as far as the enforcement, I don't know what order to enter. So it's almost like moot. I mean, I'm not going to require him to sit at home all the time. Your daughter's 16 and all that kind of stuff. And I don't, and if your daughter talks to you and says, I don't like it down here because I'm all alone or something like that, my other option is to have a custody hearing, return custody to you. She goes to you, and you just say, sorry about school. You can renew your motion for that next week or 2 weeks from now if you want, because I don't think you know what you even want to do, really.
I just hate this. I want her to be in her school she wants to be in. I do, sir. I do.
I understand you want her to be in the school. You want her to be happy and healthy and all this kind of stuff. Gets, you know, I'm worried that this Thanksgiving, I don't know what she's going to do. Are you planning on picking her up for it?
If it's mine, yes.
Well, all right.
I'm gonna go look up and do my fact. I'm going to go look up the Ottawa County.
And what if it's not your time? You're gonna leave him with him?
I have to, don't I?
I'll let you look it up and see what you want to do. I will give you if you wish to renew your motion to enforce, you don't have to pay a fee for it or something like that. You can renotice it if you want.
And I just go downtown and just reapply that.
You will just renotice it and say, I'm bringing on the motion to enforce. All right, renotice it for my hearings.
Okay, and can I tell you that?
Well, you can't tell me that. You got to file papers that says I'm
just
renoticing it for 2 weeks from Friday or whatever. Because at this point, you don't know what you even want.
I just want my kid taken care of. That's all I know for sure, sir.
I know. It's lucky that she's not 8. All right. She's 16 and does have some skills. Apparently, she seemed like quite a skillful person in here. All right.
She just has a soft heart, though, and then wears her arm on her sleeve and just gives in a lot, though, too.
I don't know. All right.
So I'm sorry, can you tell me one more time what I have to renew? Just one more time while I write it down.
If you want to notice your motion to enforce the judgment, which I don't even know what you're saying on it, but you can get back in front of me and I'll take a look at something. If you gotta have something that you're asking for an order. Okay. I'll give you an order that says father is to appropriately take care of the child. And that will be a great order. Is that what you want?
He's breaking the order is what he's doing. Sir, you told him you couldn't do that evening job if she's going to be with him, and he said okay, and he's still doing it.
He was given an order that he couldn't drink.
And that he did that, and I had that on
Defendant
video.
is not to consume any alcohol during his parenting time. You want to hold him, you want to have an evidentiary, well, you got to file appropriately to get him in front of me for that type of a hearing if he violated that order. You have to file an order to show cause and go through everything you need to.
I think I did that on there. I did that on there, didn't I?
No, you got to serve him personally. You got to set all kinds of stuff for him.
I did. I served him personally.
For the order to show cause is different. You have to do this, okay? You got to follow the court rules. As far as the other order, she shall attend Thornapple Calgary for the reasons stated on the record. There's nothing else in that about what he had to do. I remember him stating he didn't have to, but there's no court order that he can't work. My recollection is your daughter probably thought he was going to get her a job there. I don't know. Whatever. So I don't know. So
I mean, I'm going with the missing school 2 days in a row when it could have been avoided. That's everything. That second job is keeping him from doing anything that she needs done. Any parenting, anything. And he got those when her ear is inflamed so bad and her teeth are aching. Like he can't just keep putting that off like that. He should have got her in right away, and I was not notified of any of it.
So you want to change custody?
Yeah. In the meantime, I'm gonna try hard.
File a motion to change custody.
Okay.
That's all I can do, and you can find out if we have advarca or proper cause and change of circumstance. I'll look for. You will have to file a separate motion to change custody. Good luck.
Thanks. And sir,
what
do I do with that whole money thing? Is that just another? I have to go back again.
We'll send you a notice.
And somebody wondered.
Thank you.
I'm not going to mention names. If that was a walker sitting there.
If that was a walker sitting here?
That you're.
Who said that? I want to know. No, it's a huge pile of files that what's the case number on number 1?
And it is just the defendant.
Always has been?
Always has been.
Tracy, no, I thought it looked like a walker too.
Who said that?
My sister.
Gee.
Yes.
Did you give notice of this motion to Melissa?
We have a no contact order. She put what, PT order or whatever. I told my son, and I'm pretty sure that was done. I'm not sure what's going on.
Well, if you didn't give her, unless you sent her notice in the mail or something like that of this motion, I can't hear it. She's got to have a chance to respond.
Like I said, I had my son do it, but not exactly
That's not
sure.
proper service at all. And your request here is for a change of child support because of rent increases, and she bakes cakes or something like that. And you say she's not using her money appropriately, which wouldn't call for a change in child support anyhow, because this order is only 6 months old. But she at least has to have notice. You have your older child, which is 19. You don't get credit for that. Child support entered on 5/23 seems to be appropriate, but you can certainly argue it if you want, but you can't argue it unless you get proof of service to her.
So what do I do now?
I can't hear the hearing unless she has notice and you have proof of serving it on her. And it has to be served, if it's by mail, at least 9 days ahead of time. If it's served in person, it has to be at least 7 days ahead of time. You can't tell your son to tell her about it and stuff like that. You have to give her formal notice of it. And as I say, I'm telling you up front that I don't know the the idea that your rent has increased and that you now have Keaton, which doesn't, he's 19. I mean, he doesn't come into play in child support. In the last child support order, as I understand it, she even agreed to lower what it would have been, which was 5 something, and she agreed to go with 400 as I recall, although I could be wrong.
So what is it that I have to do? Because like just don't feel like it's fair that she gets to abuse the government and I get to pay for it. Like she doesn't do anything. She has all this income that she's getting and she's not reporting it. So how would
I have
would
no
be able
idea
to,
that she has that income, and you're gonna have to show to the friend of the court or myself that you have proof of this kind of stuff. Her baking a couple cakes isn't gonna do anything. My understanding is the last time that the court reviewed it, she was showing that she was on SSI, which is an income or a income that you cannot consider.
on that. So basically what you're saying is I have to get proof of everything that she's doing wrong and bring it into the front of the court?
Well, I don't know what you're gonna say she's doing wrong. If she is making a significant amount of income and you can prove it, then go to ask for a review of the child support.
She gets her food stamps money and she buys ingredients to make cakes off of that.
Sure. She can spend her money how she wants and can spend.
That's not what I'm saying though. So what I'm saying is like I'm just paying for all the stuff that she's doing wrong. Like it's she's being investigated right now by that and also by the social security because she's not disabled either. That was been faked since she's got it.
I don't know what to tell you. If they come through and say something, you might want to try it. But your son is 17. You don't even have to pay child support much longer, and it's not retroactively modifiable.
Well, the thing I heard about that was because I guess what she was saying that she was going to try to keep him home for whatever long so that she could get child support for him until he was like 21 or something.
Well,
even though that's legal,
attorney because child support doesn't go till you're 21. So you can say whatever you want. You don't know what you're up against. It does not go till you're 21. And so I should mention for the record that I'm discussing the matter and that Mr. Ramirez filed a child support request, but did not properly serve the other party. I can't hear it, but I have told him that he's requesting a child support modification, and there just is no change of circumstance that I see. He states that his rent increased, so he doesn't want to pay it. He states that his now 19-year-old son is living with him. That doesn't provide it. He says she is apparently using some of her money, state assistance, to buy stuff and sell other things. I don't know anything about it. The child support order was entered 5/1/23 and appears to be appropriate at this point.
Okay.
So you can head on to whatever you want from there. All right. But if you wish to renotice the motion, you'll have to make sure she gets proper service. Good luck, because the bottom line is I might even end up just sending out an order of an evidentiary hearing because Mr. Rostick wants custody, and there's a judgment of support that custody is given to the mom without prejudice to either party. So I have to have an evidentiary hearing for that. Even though some of the stuff that he says afterwards is just kind of strange, but if he wants a custody hearing, I just have to give him a custody hearing. Matter of Rostick versus Love. Miss Love has never logged in. Sir, did you give her notice of this hearing?
Yes, I did.
How did you do it?
I dropped it off myself.
When?
The day that I got the paper. What day was that?
27th?
It was either the 27th or the 28th. I drove to Lansing and dropped the paper off myself.
To her?
Yes.
Oh, all right. Well, then I guess there's proper notice. This is a request, and I can hear the case. This is the request from the father, the plaintiff, regarding custody. There was a judgment of support that was entered 10/3/2022, and in that judgment it says custody to mom without prejudice to either party, basically coming and asking the court for a determination of custody. They're their standard orders now, and I'm trying to. The mother has initial custody of the child without prejudice to the determination of either party's custodial rights until otherwise determined by the court. That order it also indicated the children live with father. However, there's an affidavit of parentage in place for each of the children in which the parties have agreed to that the mother has initial custody of the children. Therefore, physical custody, legal custody was referred to the friend of the court. Did nobody attend the friend of the court, or what happened with that?
I think we were supposed to. I think we were supposed to go to court. I think maybe like a year ago, and then I don't think we both ended up going.
All right. So where do the kids live now?
They live with me.
All right. Well, the bottom line is this order says that the initial custody of the child without prejudice to determination. I actually have to have an evidentiary hearing because I can't give anybody custody on a Friday morning, but it says that you're allowed or she's allowed to ask for a custody hearing.
Okay.
And I got to have it. So what I will do is we will send notice out to you for an evidentiary hearing for custody. You're
Okay.
going to have to read the notice. Everybody fails to read the notice. It tells you what you have to do, including when you come in, I have to have a formal custody hearing. Okay. So, that means you got to know what evidence can and can't be admitted. And you got if you have stuff that you want admitted, you got to exchange it with her a certain number of days beforehand.
Okay.
And you may have to give her a witness list and a trial brief. Please read it because it's going to be an in-court hearing. The best move you could ever make would be to hire an attorney because they do know this stuff and you don't. But I'm just telling you, please read it and make sure you follow it because so many come in and have no idea what they're supposed to do because they just didn't read it. All right. You got to know how to deal with each of the custody factors, the best interest factors and things like that. Okay. Which you're probably not real familiar with. All right.
Okay.
I'm just telling you, and I would tell her the same, that if you're thinking, you probably would like to hire an attorney to do that for you, but we'll send out a notice. Sir, it's not going to come before your notice will come out, but you won't have a hearing before next year. We're
okay.
Right. But we'll give you an evidentiary hearing regarding custody. All right.
Okay. Appreciate it.
Thank you very much. Take care. Have a good weekend.
Thank you. You too.
Thank you.